Hello.
How is everyone tonight?
I'm good. How are you?
I'm good. I want to welcome Charmaine and also Travis, the lawyer.
Travis, the lawyer.
How are you tonight, Travis?
How's it going, Travis?
It's good. It's good. Yesterday it was about 80 degrees and clear, sunny, beautiful. And today it was about 65. So it was a bit of a shock, but clear, beautiful day. So out getting a bunch of stuff done all day and looking forward to this. And now it's here. Boom.
Yeah, they went really quick. Sunny's not here. She had to go to Save on Foods or something. I don't know, but she's with husband and Adam is taking the reins. But I feel like the questions that I have for Travis are going to fill up a lot of airtime. So I'd like to just get started. So what I did was, because every time Travis is on this channel or any other channel or in our other chat room, I'm always bombarding him with questions. And I think so many that he doesn't get them all answered. So I just asked Sunny if we could do it this way instead. And then I put a call out for people. If you have questions for Travis, let me know and I'll ask him. And then if you guys have anything in chat that you want to ask him as he's talking about things, I think Adam is going to highlight the questions. And so just to keep everything rolling. Is that cool?
That's cool. Great.
So I don't have anything right away to put up on screen, Aspen. So a lot of the questions, which is great, a lot of the questions that I got from our friends kind of lead into some of the questions that I had that I needed clarification on. So I got to kind of pick and choose which ones and which order I go in, so I'm not asking the same questions twice. But Debbie, Deb's True Crime Notebook, she was good enough to send me a few questions for Travis. And she would like to know, does Nick McClelland have to publish his witnesses? So we saw that one filing, I think, where it was, or we didn't see it, it was, the list was actually confidential. Is that something that he has to release?
Something that he has to what?
Release to the public, like maybe not to the public, but do you know what I'm saying? It was sealed.
I saw the thing. Just so you folks know, Charmaine sent me some documents to review that might bear on some of the questions. And I really appreciate that. It was only 472 pages, but I got through all of them. And I'm kidding. But one was his state's notice of witnesses and exhibits. So, both sides are typically required to give the other side their list of witnesses. Sometimes exhibits too, but in this case, it's both. And then normally we just file the witness list and we might redact addresses and phone numbers and emails from it. But this case, because of the gag order and the protective order, may have made things such that they sent lists to defense counsel and they're just confirming it and filing a notice that they've complied with the rule and the deadline. Normally it's listed out, but because of the prior orders in the case, they can certainly do it that way and be in compliance. And then let's see what else on that. I think that kind of covers it. The defense is required to submit theirs too. I don't know if it's the same day or not. In Texas, we don't, the state's required to give us a witness list. We don't have to give one to them. And in Texas, the state can demand that the defendant give notice of who their experts are going to be, and they have to be supplied 10 days before trial. So it's different in every state, but Indiana also has other things, like in a criminal case, you can automatically depose, take depositions of the state's witnesses. We don't have that. Some states do. Indiana is one. And so that's beneficial to the defense. They can find out even from a reluctant witness. In Texas, if someone doesn't want to talk to us, they don't have to. In Indiana, if there's a witness and they won't talk voluntarily, you can notice them for a deposition, and we've seen that in connection with the contempt hearing. It's depositions on March 1st, apparently, but yeah, so both sides need to exchange witness lists. The state's done it just by saying, we've sent them our list of witnesses, our list of exhibits, but they don't list them out, which that's still going to be in compliance.
Okay.
Thank you.
That makes sense. There's another one that I think kind of starts going into the weeds of what's been going on here the last few days. And first, I'd like to just point out that the other night when you were on, to wrap up the show, you asked us all what we thought of content creators being so involved. And I think the conversation started because of the CW documentary that you brought up. And it was just really interesting timing to me that the following day, we were kind of bombarded with this witness list for the contempt hearing that was filled with some pretty popular content creators. So Deb asks, is it okay for the defense and the prosecution to seek outside help in gathering information about a case, like from YouTubers? Like, is this something? It's not like consulting a witness or an expert or something like that. This is something completely different. So what is being, I guess, alleged here or insinuated here, is that okay? Is that allowed?
Well, so I was actually thinking about that very thing today. I've seen cases where the investigating agency has put out a call for help on news media and set up a tip line. We've all seen that. And I've even seen, in some cases, I haven't had to do it, but I've seen some defense attorneys put out their own tip line. I'm pretty sure they did that in OJ, but I'm not sure. But I'm aware of, more local cases to me that I was aware of that they put out through different media channels, tip line and information and so on and so forth. And so there's nothing that prohibits doing that. Typically, when defense attorneys do it, what I've seen is they're looking for witnesses. Something may have happened in a crowd, and they're looking for somebody that may have been a witness to it. They know there's other people that saw what happened, and they're trying to get them to come forward and give a statement to them, and they're fact gathering. But both sides have investigators that they send out to get information. That's how they normally do it, not through appeals to through YouTubers. But whatever the platform is, like, what's the fundamental question? What could they possibly know? I mean, what information do YouTubers have, or anybody else,
get it, right,
about the case? It's generally they don't.
In a way, it's almost like not that it would be usable information, but that, at least in the cases I've followed, the information that they would quote unquote know would be more strategy than actual information, which is a whole weird dynamic in itself.
Yeah.
Yeah. So
Welcome.
Hi, Ivy.
Oh, yeah, I just popped
Yeah.
in.
Hi, Ivy. So yeah, there's a distinction between reporting on the inner goings of the prosecution team, having a mole in the DA's office and trying to find out what they're going to do next or something, and then, you know, or getting people that are close to the defense, trying to get information about their strategy and what they're going to do and that sort of thing. You know, that's a completely different thing. But if that's what's meant by getting help from YouTubers, then, you know, that's a whole different thing. It's trying to think if that's a technical violation of any of the ethics rules. It probably is. It's probably not a crime at all. But I don't know. I mean, to me, and I don't know enough about it, I'm just hearing anecdotal things from you all here over the history going back 7 years or so, and then seeing little snippets here and there. And when I was doing Teresa's criminality channel last night, seeing different things that got pulled up and whatnot. It's just really hard for me to fathom that anything's really even that credible. And I, you know, I've seen you all on this channel. I've just got so many thoughts going on because there's just so many things to this case and what's come up. But you know, it was real recent within the last few days that somebody asked Sunny to post something, and she said, no, you know, I'm not going to post anything I haven't vetted. There's just too much stuff out there. You know, I need to look at it, verify. Maybe Adam can chime in here, not about that specific thing, but it's my recollection that there have been numerous things that have been put out as coming either from the investigation or some sort of communication, whether it's messenger or text between two people. And, you know, it's just all turned out to be bogus. But, you know, in every case, and even with those tip lines, and I've been involved in cases, part of discovery, we can get all of the tip line information. And 95% are people that are trying to do the right thing. Their calls start with, you know, I don't know if this means anything, but I thought I would just call it in. You know, I saw a red, you know, 1970s vintage make model car around that area around that time. And you get hundreds and hundreds of these calls, and, you know, most of them are nothing, but then every once in a while you get something significant and they follow up on it. But I guess it's just, I don't understand. You know, I saw the list of the documents and the descriptions, and a lot of it was people claiming to be working for the DA or helping the DA, or that the DA told me to delete stuff. At this point, I have no doubt that what Hennessy is describing is accurate, but he's describing third-party conversations. We have no idea if the person was really told by the DA to delete stuff, for example. And I just kind of really doubt that, unless I see it and there's something there or there's testimony, I know that there has been what I'll describe, as a market for information in this case, and people selling things to content creators, because there's, for a long time, I guess, there's no information whatsoever. And so there's just really nothing to talk about. And that's happened in other cases I'm aware of. People are selling things, and, by and large, a lot of that stuff just turns out to be bogus. Not always, but sometimes. And this case is just really, really unusual. I haven't seen a case with, this much of that going on, that it was, part of that GW program.
Mm-hmm. So, but the insinuation is there, and the information is out there, and people are, for the past couple of days, we're seeing posts and stuff just in more drama based groups, I guess. So, and you can't really believe everything or anything at this point because it's not on a court document, but here we have court document with certain, not even accusations, but more insinuations that this could possibly be something. And Miranda Lee had a few questions as well. I'm going to skip some of them because they can come after, but one of them was like, how would that affect, if this bears out and any of it is true, how is it going to affect the trial? Like, if either side, if they decide whatever, that Baldwin knowingly leaked those pictures or was aware of it, or Nick McClelland has done what is insinuated here, how is that? I watched Bob's live last night, and him and Ali were both saying it would not be in anyone's best interest, including the defense, to request a special prosecutor at this point because they've requested speedy trial. So, like,
yeah, and
like,
I had actually posted that in that defense diary chat that you were in, and said, they're not going to, I don't think, seek to move to disqualify the DA, because that in and of itself puts off the 70-day requirement, because they're because if it's granted, the new prosecutor gets a new 70 days.
Okay. But so I think the question was, would it be like an automatic, like if either side, is that an automatic dismissal, removal, not dismissal or whatever, but does that have to be kind of dealt with first? Because those are serious ethical violations, are they not? And going into the...
Well, they certainly could be serious ethical violations, or they could be nothing. So what's a serious ethical breach is a prosecutor sending in people to gather information on the other side's strategy, work product.
So is that an automatic, something that the judge automatically has to deal with? If the defense doesn't say, I want a special prosecutor, like, does the judge have any obligation to step in and say, okay, on either side?
No, I don't think there's a, I don't think they automatically have to do something, because that document that listed out that Hennessy filed, that's for the contempt, and it's just a description of documents.
Mhm.
Court hasn't seen any of those documents. And now if part of the contempt hearing, documents were submitted to the court for review, or admitted into evidence, either one, and there are serious questions about that, would the judge have to intervene if not requested?
Because the Supreme Court, they kind of listed out all the things that were necessary for disqualification or the removal. And
Well, so the removal of defense attorneys, that's a great point. To remove defense counsel is a whole different thing than removing a prosecutor, because the removal and what the main thing that caused the Indiana Supreme Court problems is that you have a Sixth Amendment right to counsel. With retained counsel, you have the choice of counsel. And then, after she removed Rosie and Baldwin, one of the issues in the Indiana Supreme Court was choice of counsel. That if you have the money to hire somebody, you're entitled to your choice of counsel. But with appointed counsel, you really don't have that same choice. It's more limited. But they did find that because they'd been on for so long, that the only proper way to remove defense counsel is if they're ineffective, and ineffective in terms of constitutional right. They're not showing up to court. They're not hiring experts. They're not doing what they need to do. They were very clear that that's the only basis that you can remove somebody. The other remedies are, if it's not ineffectiveness, if it's contempt, you can bring a contempt, or sanctions, just this generic thing, sanctions. But with a prosecutor, you can remove a prosecutor if there's a conflict of interest. I would think if there's serious ethical violations, but I don't know if the court can do it sua sponte, look at a bunch of different things and say, sorry, but you're out of here. And so what I'm trying to say is there's like a bunch of steps to even get to that point. All we have right now is a list of general descriptions on some documents that, with a couple of exceptions, don't appear at all to even be directly from the DA or to the DA. It's just people saying, yeah, the DA told me to delete them. And that could be true if it's one of the two or the three that they were talking about. It wasn't a recorded conversation, but it was memorialized in email correspondence that this was the deal about YouTubers aren't journalists, therefore the privilege doesn't apply to them. And what the privilege they're talking about is the reporter privilege, and which they have in Indiana, that you don't need to reveal a source, which I thought that was interesting. So, she said they can go and, the investigators can go and talk to these people, and the privilege doesn't apply. I can put them in jail, and the privilege doesn't apply. And then I think there was some discussion that was memorialized about they think they've got it contained. They've talked to the folks. They've agreed to delete. So that may have occurred. Somebody said, yeah, delete these documents. But, until we see what those things are and what they are, and more importantly, the court sees what they are and who they're between, they're just a list of stuff on the paper. It's nothing. Certainly what's there now wouldn't trigger anything on behalf of the court. Now, Hennessy's able to show Rozzi and Baldwin everything he's gotten, either through their investigator or through subpoenas for documents. And, they would know and would evaluate whether giving up and starting the 70 days new again is worth that versus disqualifying the DA. Why the DA withdrew the motion rapidly is that if a DA obtains too much information in a way that they shouldn't, like they do a search warrant for a phone and it has a bunch of attorney-client communications, and they don't stop reading. They read all of the attorney-client communications. There are plenty of cases that say you should have stopped reading. You should have turned the phone back over and demanded that they separate the information and instruct, whoever the investigator, whoever obtained the cell phone information, I don't want any of the attorney-client stuff. Just get me, who the person talked to outside of an attorney. If they don't do that, they've been disqualified. But every case that I can recall, it was at the request of the defense attorney. The court never did it on its own. But that's why they were really quick to withdraw that motion, because that could trigger a disqualification.
Mm-hmm. And I'd like to say just quick before I move on to another question that I think anybody that received the leaked crime scene photos, they were told to delete them. So that insinuation could just be that.
Absolutely.
You know what I mean? Like they could have a text message or an email that says delete that please or whatever, but directed at those crime scene photos, because that's what everybody was told to do.
The wording in mine actually said destroy.
Okay, destroy.
I went back and looked after that, just to see, the context. And yeah, it said destroy all, I can read it right. It said, destroy any remaining copies and anything else.
Okay. So
Do you mind if I ask a quick question real quick?
no, absolutely.
A two-parter. But one is, would say screenshots, not emails, but screenshots, would that even be, like, how could they consider that evidence, considering how they could be manipulated potentially. Like, do you think that that would be allowed as evidence?
The screenshots.
Yes.
Screenshots can be evidence, but you have to lay a foundation. Typically, you need one side of the conversation to authenticate that, yeah, this was me talking to another person from my cell phone. It's an accurate screenshot. I haven't made any changes, additions, or deletions to the screenshots. It's true and authentic, but you typically have to have somebody who can authenticate at least one side of the conversation. Same as a phone call or anything else.
I was going to ask if that same situation, but say you took a screenshot of like people in comments like on Facebook or something like that, where you can authenticate that you took the screenshot, but you can authenticate that the people are who they are.
So if you are getting information in this day and age, the last 10 years, certainly the last 5 years, when you have a case, everybody goes to the social media pages of if you're the defense, you go to the social media pages of the witnesses, any social media pages of friends and family of the victim, and you gather all of that, and you gather who's participating in that, who's a supporter, because you're trying to establish, okay, who has bias one way or the other for either side. And so you'll typically have a witness's Facebook page and postings, and you're able to use that in cross-examination. We have our investigator obtain it. The state does the same thing. They have the police agency obtain the social media stuff, and they can authenticate, yeah, here's Joe Smith's Facebook page, and there's a picture of Joe Smith, and this is a true and accurate screenshot of Facebook page where he's posting something that shows he's clearly biased against the other side, and you can cross-examine with that. But that's going to be a different context than what these things have been listed for in contempt. To me, those things are listed as an abundance of caution, depending on which way the testimony comes in. But the way that the only real way that they're relevant is, those things aren't going to come in by themselves. There's got to be somebody to authenticate them. And the only way I think, the only way probably that most of those documents can be used is if the person they're referring to, the DA or, Nick directly, is if they can somehow get Nick on the stand.
That's one thing I noticed. You talked about it on criminalities, is that so Fig, that was a lot of the exhibits were his, but he wasn't on the witness list.
Nor has he been subpoenaed, nor has he actually been contacted in regards to this by the defense at all.
I don't think there's any subpoenas that I've seen of any of them, is there?
No.
Who was it that wasn't subpoenaed or listed?
That's Gary is his name in there.
Oh yeah, okay.
So, like, most of the exhibits are things from
Right.
him or having to do with him, but he's not a witness, so they're
Yeah.
listed.
Yeah. So that even, reaffirms more in my mind that those things are listed as just in case and out of an abundance of caution, and
Mhm.
probably won't see the light of day until if they're referring to, so if Charmaine and I are texting each other or emailing each other or messengering each other about me, my inside information I'm getting directly from the DA asking me to help, and I don't get subpoenaed, it's just so far attenuated. It's so far removed from what the issues are with the contempt. The only way those could possibly come up is if the DA gets called to the stand and they're asked to confirm or deny that such communications existed. It just doesn't, it's just not going to come up. And then trying to think of an analogy, it's just, most of it, it's really difficult to even conceive that any of it's illegal, except that list of items that the ladies riding around with the investigator Holman, allegedly, and driving around town in circles. And she gets do I have this right? And she's getting a list of things. The victims were not this. There's no evidence of any this. And that gets circulated. And I think she's the wife of somebody in LE. Do I have any of that right?
Yeah.
But
I didn't realize that she was the wife of another police officer, but could definitely be possible.
That's what I heard. I don't think it was in the document, but that's what I heard.
Yeah, I'm not sure.
okay.
I thought she was helped create Bridge of Lies Facebook group with Doug Rice.
I heard that as well. So
And that was a while
okay.
ago, several
Yeah.
years ago, if it happened.
So that in Texas, that would be a crime for peace officer to release confidential information to a lay person. That's a misdemeanor in Texas. I don't know if it is in Indiana or not. So that's a big problem. If Holman, which that was, I think that surprised a lot of people that he was doing the investigation of the leaks. And maybe it's because people were aware that there were allegations that he had leaked stuff. So if he would have to be called as a witness, I don't see any way around that, because he did all of the investigation on where these photos got to, and then how he came to the conclusion that it came from the defense side, specifically.
He's a state witness. He's a state witness for the contempt hearing.
right,
For the which case?
contempt.
For the contempt.
And Holman was the one who was investigating Westerman and tracking all of that too, right?
Yeah.
So there's no way they have to call him. And so a lot of this stuff is showing that he may have, a bias in investigating this. a bias in trying to establish it's only coming from the defense, and nothing came from the state because he leaked stuff on his own allegedly, but that's all listed because it may be used for cross-examination, those types of documents. And this stuff about people with no firsthand knowledge communicating with each other. And when I mean firsthand knowledge, I don't see things about emails from Holman to so-and-so regarding whatever, or emails to Holman, or emails to the DA, emails from the DA. I didn't see much or any of that. That stuff would all come in. This third party stuff that's, removed doesn't have a very high likelihood of coming to light during the hearing unless something else ties that up and connects it.
So I'm just writing down because I want to remember I got another question regarding that, but I don't want to talk about it right now because I want to get to the one and only Tom Webster. He gave me a couple of questions for you as well. One, I don't think that we can really quantify it the way that everybody hopes we could, but Tom asks, how much evidence will the defense have to provide to the jury to try to get them to believe that odorous are involved? Baldwin and Rosie said that there's a significant amount of evidence pointing to that. That's Tom's number one question, and the other one gets into what everybody wants to know, so that's why I asked that one first.
Okay, read that to me one more time.
How much evidence will the defense have to provide to the jury to try to get them to believe odorous are involved? Baldwin and Rosie said that there's a significant amount of evidence pointing to that.
Okay.
So I don't think that's anything that we can actually quantify.
Sure we can.
Can you?
So I can't tell you, in terms of number of documents or numbers of witnesses, but how much evidence, what's the quantum of evidence they would need to show about odonism or any other material aspect of the case. It's pretty simple. It's reasonable doubt. So they would have to show enough evidence to a jury to get them to form a reasonable doubt about whether the perpetrator was a practitioner in a particular religion or sect or cult or anything else. And so that's what it's going to take. Sometimes, it's going to depend on the credibility of the witnesses offered, if there's experts, what these photos show, which in this case we know are runes. But we do know, and he and, a lot of you, but he did a whole long series, multiple hour series on the memo in support of the Frank's motion, which is where my understanding is that all of this came to light. And things about an expert, and this is part of the documents too, that they were asking who is the expert that they consulted. We know an expert was consulted because in the deposition of investigator so-and-so who's retired, he confirms that an expert was consulted at this particular university, and they're holding this from us, claiming they can't remember. So through these depositions that they conducted and their investigation, they've discovered that at least one or more investigators that were working on this case had established a theory about signs being connected to a particular religion, sect, or cult. And therefore, the perpetrator would have to have belonged or practiced in that particular religion, sect, or cult. So that's one. And then they're also able to show problems with the investigation, that there was bias, for example, there's disagreement on things to pursue. So they got a lot of good information from what I know about the memo in support of the Franks motion. But what amount of evidence it's going to take is,
Isn't it very subjective? Based on,
yeah, it's going to need to be more than speculation and conjecture, but Tom will understand this from seeing his presentations on the memorandum on the Franks motion. He had a really good grasp of what was going on there and kind of presented things balanced on both sides. I really appreciate him doing it because I didn't have to read it because of that. But first, the state's got to prove that Richard Allen did it. And so it's a function of if the state gets over that hurdle, then the defense is going to have to come back and establish and create reasonable doubt about the connection of religion, sect, or cult being involved in the murders, and that their client isn't part of that religion, sect, or cult, and therefore is not the perpetrator. But they're not even going to have to offer any evidence on that if the state doesn't prove their case to begin with. And you don't know. You don't get to pull the jury after the state rests and say, hey, so where are y'all at? Do you think our guy did it? No, you don't get to do that. What you get to do is see how the evidence comes in, and you pretty much present your defense no matter what, because you don't know, and you've got to present it. But like anything in the trial, either on behalf of the state or the defense, they're going to have to show that they can link that unspent cartridge, bullet, unfired cartridge to a gun owned by Richard Allen or in his possession. They're going to have to prove that beyond a reasonable doubt, and how much evidence, the quantum of evidence they need for that, it's impossible to quantify. But what typically you need for that is a tool mark expert, and tool marks is the study of the markings on bullet casings, cartridge casings, technically more accurate, being ejected from a weapon. That's tool marks, as opposed to ballistics and other stuff. And typically a state expert or an expert from the FBI lab is typically enough. And then you've got to counter that with, good points on cross-examination and or your own expert. And, the jury weighs that and determines if there's a reasonable doubt in that or not. But that's ultimately the quantity of evidence they would need to show in order for Odinism to matter in this case, is They'd have to present witnesses who the jury find are believable, credible, and that they buy that
Theory.
theory. Thank you.
All right. So just about every single person that sent me questions, we all want to talk about ex parte, ex party, whatever it is. And I know that I did kind of bombard you with questions about it the other day, or yesterday in chat. But so okay, I'm just gonna let you kind of talk about it. We want to know. Okay, can he just? It's ex parte, so it says that right at the top of the document. He's a lawyer. He knows better. Why? Okay, just explain this to us. He kept reading even though it was ex parte and he knew, and then he put in this withdrawal that he did it before in December and whatever. So it's happened before and these things were being filed incorrectly, but it still says ex parte. So what I'm wondering, and everybody else is wondering, what's going to happen now? He can't just pretend he didn't do that and he's not aware of this part of the strategy, or how is that all going to affect how the judge rules on that ex parte? And then later, is this right here raising more issues for appeal?
Okay, so the first part, issues, man, these are hard. Maybe I shouldn't have started with a cocktail. Anyway, so
I should have had more.
You just need another one.
Okay, so you, in the materials you had, I don't know if Adam can bring it up, Kara did an excellent explanation of what these ex parte motions are for in the context of a criminal case and getting experts. And so if we need to go over that, we can, but ex parte motion is any motion that you file that goes to the judge without the other side seeing it, at least initially. And there's all kinds of ex parte motions. They're really common in child custody cases where one parent has essentially kidnapped the child or is not allowing any type of visitation, then the other parent goes in ex parte. They don't let the attorney for the other side know, or if they, more importantly, they don't have an attorney, so the notice would have to go to them, and you don't want to send notice to the parent who's abducted the child that you're trying to get an order that a police agency anywhere in the United States can detain that person, take custody of the child, to arrange for the other parent to get, the rightful parent to get the child back. So that's one type of ex parte motion. And there's, hundreds and hundreds of ex parte motions. So
just really quickly, is there ever an ex parte motion where the other side is privy to it, that can freely access it and use it in court filings, just before you move on?
Yeah, there are. It's the if so, motions typically, well, not typically, all motions you're supposed to notice the other side. And That's a requirement. And you're not supposed to have any ex parte communications with the court. And, that's an ethical violation. And so submitting a motion when you know there's another attorney on the other side, you're required to notice them unless it's proper to do a particular type of motion ex parte. And so outside of the criminal context, there are all kinds of ex parte motions that are proper, but you still notice the other side. And because you know that there's an attorney, they're entitled to notice, but the judge doesn't have to hear from them if they don't want to before deciding. And these things are like on preservation of evidence in a civil case, like a wrecked product, car, or something. But in the criminal context, about the only ex parte motion that there is on the defense side is requesting funds for an indigent client for an investigator or experts. There's nothing really else. So, and then, the state's entitled to ex parte motions on a number of things. In fact, they don't even have to get motions for a lot of them. So one thing, the DA, if there's 3 defendants in jail on a case, can order that they, be kept separate so that they can't be working on their stories together, things like that. And they don't even need a motion in most places, but in those that they do, they can request that ex parte. But from the defense, this is about the only thing there is. And as Kara mentions in this description here, she lays it out really, really well. Why there's a need to do an ex parte motion to get funds, and why the state isn't entitled to this information, why they don't get notice, why they can't look inside the motion. And so you guys played a local television snippet about this, and I think they talked to a longtime defense attorney there, and his comment was, this just doesn't seem accurate. The DA saying, oh, I wasn't aware, I wasn't supposed to see this. And I said in the chat that, I thought that was very disingenuous in light of him being, a former defense attorney who handled indigent clients who would have had to have presented these motions, who would know the devastating effect if the state knew why you were hiring certain experts. And certain experts you hire, they start out as consulting experts, and probably like in this one. And I think people kind of got confused about what the motion was for. The motion was the ex parte motion, and again, we're basing this off the DA's third motion to obtain medical records, was the defense wanted to hire an expert to look at the conditions in which Richard Allen was being kept, which they contend are abusive, improper, whatever adjectives, but that they wanted to see if the conditions under which he was being kept would contribute to his falsely confessing. I think some people kind of got confused that they wanted the medical records because he confessed to a doctor. That's not the way I read it. I may have misread it. I skimmed it, but
No, I don't think that.
they weren't looking for records for confessions. They were wanting to look at the mental health records and possibly medical records because he wasn't eating and so on and so forth, may have been malnourished. They wanted to see if what an expert would say, looking at those conditions, what that how that might correlate to somebody saying they did something that they didn't really do. It's as simple as that. And whether so he said, based on that, I'm entitled those records. We want to be able to see them so we can prepare for this witness. And then, suddenly the light turned on for him. Oh, I didn't know I wasn't supposed to be reading this or whatnot. Now, I don't, Kara in her thing here, which there's no way I can read that, but,
That's right. I don't know if Aspen can make it any bigger.
You'd have to zoom in on your screen, Charmaine.
I did, but I think there's a way that you can make it full screen and take us off.
Oh yeah, I can do that.
Like I can read it.
Oh, wow. So let's see. Sorry. Okay. I don't see the part where it talks about what the process is for filing it in
That's
one
a
of
different-
two. Oh,
That's a different tweet? Oh, okay. Well,
okay. That's okay. Anyway, so she talks about that in Indiana, they do it one of two ways. One is they hand carry the ex parte motion and drop it off with the judge, or if they catch the judge there, they can present it there to the judge. And a copy is kept on behalf of the court in some form or fashion, but it's not filed, so no one can ever see it. And I've talked about this in the past that we know there have been ex parte motions for experts because it's been mentioned that the judge mentioned that she's approved different she didn't say for what or who, but that she's approved or disapproved certain things, and none of that was inappropriate. So I knew there were motions. And then we know that in Indiana, the public has one level of access. Anybody can go into their electronic filing system, EFS, and look at what's been filed. You can't, their system, you can't download it. You have to make arrangements through the clerk to get copies, but you can see everything that's been filed. And as far as I'm aware of, I've asked people to check, and I said, no, I don't see any ex parte motions regarding anything. And then there's another level of access where attorneys, licensed attorneys, and that's the same way in Texas, our system. If you're a licensed attorney, you get another level of access that allows you, generally about the only thing it gives you is the ability to download documents. So we know it wasn't done that way. The other way that they do it is you file it with the clerk, and that you request that it only be accessible to certain parties, like the court, and nobody else. Now, she wasn't real specific in there. Do you have it up? No, it's up above on the far right, in the far right column, and it's a little bit up from that, I think.
Sorry, Aspen is in control. What are you
Okay.
looking for?
Okay. It just talks about there's two ways we file ex parte motions.
Okay.
One is
Oh, that's in the middle on the top.
That's the one I've got up there.
anyway. So the others that you do it, and so evidently, you know, in his little brief, he said, "Oh, I pulled it up. I didn't realize I wasn't supposed to be looking at it. There's two others that everybody can look at." And I said, you know, I thought that was disingenuous. An attorney from that area, a long time, said didn't make any sense to him. You know, he would know what that is, but you know, I don't know what to make of the fact that the clerk filed it and didn't lock it down to only the judge being able to see it versus nobody else. I don't know if that's something that they were supposed to do. There was something they were supposed to do and they didn't.
The whole issue of filing, and it sounded like they were still kind of confused about it, happened in that, what was it, the October 19th hearing? In that, that, can't think of the word, you know, where they write up what happened, what was said, the transcript.
Right.
For that, I can't remember if it was Baldwin or Rosie, but I remember them asking her, so is this how it works to have things under seal? And she said no. And then they went back and forth, and it sounded like it was still kind of up in the air about how it worked.
Yeah, they were talking about sealing and that sort of thing, but you're supposed to,
that could be a different issue that I'm...
It is. It's sealing. So this isn't sealed in the same way. It's just access is locked down so that you'd be able to see a docket entry, ex parte motion on behalf of defendant, and then normally attorneys, you know, can click and download, and it's supposed to be only accessible to the court. And I don't know if they were supposed to do something special when they submitted it to.
I can read it. What it says: Indiana attorneys now electronically file pleadings with the court through an e-filing system, Odyssey, maintained by Tyler Technologies. From the attorney side of system, when we e-file a document, we initially assign it as public or confidential. We also control who receives an electronic copy, e-service, of the document. If we do not wish to e-serve a filing on an attorney listed as a service contact on the case, we uncheck the box. When we e-file the document, in other words, we file the document, but no one gets a copy emailed to them, so they don't know it's been filed.
We have Odyssey here by Tyler Technologies, and I know what they're talking about. And we do select who's on the service list, and you can deselect that, but we don't have the confidential option under our system. And the fact that you don't, it doesn't notify them that it's filed, but when they go in and confidential hasn't been selected. So, you know, if if the past is any indication of what's going to happen, and again, this is on contempt, not the criminal case. Gull's going to say, well, it's not part of the contempt. It's part of the case was to get the medical records, which is withdrawn. The thing is, if he hadn't withdrawn it, it goes back to he knows that information he shouldn't have been looking at, and that's why he withdrew the motion. And he's not aware of now if that person's turned out to be an expert witness, and we don't know. They may have consulted with that, gotten the money. She may have declined the funds, number one. And so they never hired the expert. Number two, they hired the expert. The expert reviewed all of the records and all the other information and said, yeah, I really can't help you much one way or the other. So that person didn't get listed as an expert for trial. Or the third possibility is the expert looked at it and said, yeah, there's all kinds of science and literature, and Ivy could tell you much more about this than me, about people say things, become delusional under these conditions, and you can't listen to a thing they say. It's akin to torture and Gitmo. You can't rely on anything that those people confess to, and we have data and studies on this. But so he ultimately was going to find out, and then if they disclosed him as an expert, it would say, Dr. Jones is going to testify about the conditions that the defendant was housed in and their connection to any alleged admissions or confessions by the defendant. And each side is allowed to see anything the expert looked at that formed their opinion. That's if they're named for trial. So I suspect this expert wasn't named as a witness for trial if the expert deadline has come and gone already. They're not entitled to it. He's entitled to it automatically if they were named as an expert, but he's withdrawn the motion, so it's moot.
Yeah, well, exactly. That's why I didn't bother bringing up the whole motion. But is there any, I guess, consequences? Like what do you expect the judge to do?
Nothing.
Nothing.
It's moot. So, and that type of stuff doesn't rise to the level of, it's not a crime. It's just not a high level thing, and I don't see that as being grounds for disqualification. He doesn't say that he read the first two. I can't remember if he said 3 or 4, but I think he pointed out the previous ones. But
I've got it right here.
I think it was 3.
Yeah, it's 3, December 8th, June 6th, and June 16th. And now this one as well, which leads into my next question. So
yeah, he said, the other 2 weren't private either. But he doesn't say that, he read them in depth, but, I mean, you can probably make the assumption, but, there, I don't know, just different there. I wouldn't trust electronic filing with something like that.
Mhm.
I'd bring it by hand, and is it filed? And so I'm going to go out and get your court clerk to hand file it, hand stamp it. But I don't trust EFS. I'm not going to put it up there. And but I don't do much, if any, anymore. Appointed work. Very rare. But that it was before EFS came in strong about 5 years ago through Odyssey, all across Texas, and there's a learning curve with that, especially attorneys, trying to figure out how to file this stuff. If you have exhibits attached, how you do you just do it as one PDF, or do you do the motion as one PDF and every exhibit as a separate PDF, and on and on and on, bunch of stuff. And if I did more of it, maybe I could tell you, yeah, you do just check a box and it's supposed to do it. But
Well, I think that's what Kara's tweet actually did say when she was explaining the process. If you're not going to actually hand it to the judge or whatever, then there is a box that you check. But
I don't think she said check. Do we have it? I don't think she said check a box. I think it said you do something with the clerk
I read you the first part. It said we check a box, and then she goes on to say, after we e-file something, a clerk in the trial court clerk's office reviews the submitted filing and accepts it for filing. That's when it appears on the docket. During the review process, the clerk has 3 options for access: public, confidential, and court clerks only.
So that's what they were talking about in that transcript, that review process.
Okay. So, I mean, this would be the same thing, but it's a little bit different here. So on the sealed stuff, it would be not public. It would be not clerks only. It'd be just attorneys and the court and the clerks. But this is even more specific. It's the judge, the clerk, and defense counsel. We just don't have a way to do that. And here you'd have to know, and they're right. You submit it, and every motion, the clerk looks at it. Okay, has this been submitted correctly? Is it within the page limitation? Have they designated it correctly? And you designate it as motion, order, petition. There's about 6 different things you can pick, and then other. And so yeah, it's a motion. They got that right. It's this. Now you can put a note. There's a memo that you can type in. Please note, this is an ex parte motion. I'm not. You'll notice no proof of service to the other side. It's not supposed to be. And needs you to bring this to the court's attention as soon as possible for a ruling. You can put that memo in there on anything, and that's a message to the clerk. And we can do that, and that's what I think Kara would say if their Odyssey is like ours, which I'm sure it is. That, and then you have to hope that. Because because it's out of the ordinary. Probably 1 in 1,000, maybe 1 in 10,000 things that get filed in a clerk's office are going to be ex parte. And you just hope they remember to click the box that only the judge gets a copy of it. It's a gamble. But so here it happened 3 times,
This was the 4th time.
And this was the 4th.
So, and I'm going to put my tinfoil hat on here for just a half a second. And I literally cannot believe that I'm saying this in this group, because I don't know that other people's minds go this place. But because of the way the Franks motion was filed, should have been filed confidentially, and there were other things that the judge had taken issue with. And it's kind of, I don't want to say like an ongoing issue, but it has happened in the past. And you and I were even talking in that chat room yesterday. This is number 4. So at some point they would have been schooled or taught or trained how to properly file something under seal or confidentially, and they didn't.
But would they have known before this that those ex parte ones weren't being filed correctly?
But from what I understand it's the same process to file under seal, okay, confidentially. So my tinfoil hat thing is, could they? I don't even,
No, they wouldn't, Ivy. They wouldn't, because so this is no different than Dropbox. Okay. So I have or Google Drive. So I say, yeah, I want everybody to collaborate on something that we're going to do for Sunny and Aspen or Charmaine. And it's in this Google Drive. So you go in there and it's like, okay, here's Travis's notes about the presentation. You can look and see who it's shared with. That might tell you, but you don't have that in Odyssey. But you go in there and you have access, and unless you dig and know how to dig around, you don't really know who else has access. On Odyssey, you go in and you get an email notification after they review it that they've accepted it for filing. And so you'd be able to click in there and go, cool, it's filed and we're good to go. And it's going to get submitted to the judge. And, when they rule, we'll hear on it what we're getting approved for. But in the normal scheme of things, when you look in there, there's no way to tell on a document that the judge has looked at it, that it's all is that you have access to it and you can look at it, not what other people do. And again, I don't do much of that anymore. It was before electronic filing that I did it, but the confidential part of it, it is similar, Ivy, but it's a little bit different. This is, it's under seal. The main thing the court was messing up with on the confidential documents was not filing the appropriate sheet. Under the act, everything that is withheld from the public is supposed to have a sheet filled out as to that it's been withheld and the reasons why, so that anybody can challenge it if they want to. And that was made abundantly clear, and there was no question about how to do that. There was confusion by the court about whether the names of victims needed to be redacted on children under a certain age still living, if they're deceased. But the Princess of fucking Darkness got everybody straightened out on that quickly. She knew. The court was taking the position that the memo should have been redacted and filed under seal. And I don't know if y'all remember, but PFD filed it unredacted as part of the record, and said, hey, look at this, everybody. The court is trying to claim that some of this stuff is subject to redaction, and it's not. Basically, my take on it was she was basically daring the judge to come after her for it. And then soon after that, the judge issued an order that got everything in order the way it should be. And then they took the position in the Indiana Supreme Court that it was mooted and there was nothing else to decide. PFD filed a response to that saying, well, there's still some other problems, but, there's still these forms aren't getting filed. And then the court denied the original action, but then said, we're going to take this point to clarify what we mean by this once again, and then proceeds to lay out everything that PFD said that the court needed to do to be in compliance. So that's on if there's something being filed that's got information that should be sealed or kept away from public, or portions of the motion should be sealed. And so it is similar, but it's a little bit different. This one, it should be sealed. You should be able, no one should be able to see it. And furthermore, the state should have no access to it. And so it's very easy to see the clerk being the one that messed up on this. It's very easy to see that it's probably a legal assistant filing it. Easy to see that, they thought by clicking a particular box or putting information into the memo would have made it impossible. That, they thought they were good on that. And the clerk didn't do it. We'll just never know, but
right.
Shouldn't be looking at it and acknowledged he shouldn't have been looking at it. Kind of had a.
That he put it in, he did it before 4 times. Like, why isn't that, like Ivy said, isn't that kind of telling on himself? But if there's
but see, it's not that big a violation. It's not like it's not like something labeled in your house, top secret, U.S. government property,
or the bathroom, or your bathroom,
improper use or dissemination of this information is a federal crime. It's just not that big a deal. But every attorney you get an email from's got a disclaimer at the bottom, mine included, that says if you receive this in error, the bar rules require you to return it immediately. And so it's a bar violation. And when it does happen, say, I don't think you intended for me to get this. I read to about the 4th sentence, and it became apparent to me that I've received this in error. If I'm wrong about this, let me know. If I'm correct, I'll delete it, waiting for your response. And it happens, especially with this autofill crap on addresses, which happened to Baldwin. Apparently, it's happened to me, and so it's not it's not that big a violation that it. Yeah, he's going to say, hey, there was 3 other ones that weren't locked down. How am I supposed to know? Now, and then that's the part that I found disingenuous, and I think others as well, that you should know you're not supposed to have access to it. And you should have alerted defense counsel immediately, hey, whatever you're doing or the clerk's doing, and so that's sneaky, and that's apparently the way he practices. But it's a sneaky deal.
I think it's really helpful for one thing that you're really helpful on, besides answering all our questions, is for issues like this where it's really easy as somebody who doesn't have any experience with law to, as soon as you come across something that's against the rules, it's like you automatically go to, oh my gosh, they could get disbarred. When
Right.
there's
Right.
some things that are against the rules but are not as big of a deal. And if you don't have that experience, you don't know what's a big deal and what's not a big deal. So it sounds like, from what you just said, in a way, this is getting blown up into a very big thing. And it's probably not at this point in time. Even if he did know and looked at it and didn't do it, likely nothing will come of this, and we're just going to move on.
Probably. What is a big deal with lawyers is, the number one thing is stealing money from clients. That is the big thing, and or not managing staff properly where they're able to steal clients' money, and that'll get you disbarred really quick, or a lengthy suspension. That's the one thing that they're looking for. Or and in the criminal defense context, where that comes up, not necessarily stealing money, but because criminal defendants are in such a vulnerable position, an unscrupulous attorney can fleece them, or an unscrupulous bondsman can fleece them. And so there's controls on that, and can't overcharge and charge excessive amounts for things. And so they look at that real hard if they decide to change attorneys. And I've served on a bar complaint board. It's usually 2 lawyers and 1 public representatives, a member of the public, and hear these complaints on all kinds of cases, not just criminal. But the number one complaint is lack of communication with the clients, and then every once in a while it's stealing, and then some sort of, and there's usually some sort of alcohol or drug abuse connection with that. And egregious and unconscionable fees is another area. And so to protect the public, and the amount of power and control that an attorney has in a attorney-client relationship, there has to be that kind of oversight. But things like the bar complaints for improper conduct in court, and these things are, so minor that a lot of them, they'll say, yeah, this, technically, but in light of the number of years and no prior complaints, we're not going to administer any discipline, or it's what we call a private reprimand that at the worst. But this stuff, on its face, there's just not enough to know how much harm has been done. And I suspect because this person wasn't eventually, and again, we don't know. We don't even know if she approved the money for the expert. I assume she did because he wanted to get the materials to have an expert to look at, to address that. But I'm guessing that he withdrew the motion because that expert hasn't been listed that they're going to testify. So it's not that, wouldn't be that big a deal here in Texas. I assume it wouldn't be in Indiana.
Probably not. And I think that, Ivy and Miranda both kind of summed up that entire, question with, ex parte is right in the title, but there's no consequences really. So what's the point of even having that rule, I guess?
Well, the point of having it is that if he had pressed it, Bar could look at it more seriously. And then number two, if he hadn't, and this is why he withdrew it on his own, is, and I get he's trying to make, I didn't know. Now that I do, I'm withdrawing. Don't really buy that. But if he hadn't withdrawn it, then it can turn into a more serious thing. But why they have the rule is that if he, tried to slip that stuff in during trial, that type of stuff, it could result in a mistrial. It could lead to more serious sanctions by the bar, by the court. And that's why you have the rule. If you inadvertently let something get out, we know mistakes are going to happen from time to time, and that's why you have that rule. And if you don't delete them and you don't agree to not use them in the proceedings, you can be removed as counsel, so on and so forth. Now, if it's a big enough deal and they look through these 3 or 4 motions that have been filed and what they put in there and the information and strategy that the DA would have had, just like getting a cell phone with attorney-client communications, if there's enough in there that they feel that their defense has been compromised, then they have an obligation on behalf of Richard Allen to move to disqualify him.
Mm-hmm.
But we're so far along now with discovery. Is it discovery cutoff for both sides and witness list for both sides in the criminal case? I'm not talking about this list of witnesses.
I got confused with the contempt hearing.
Yeah.
Now it's kind of like weird in my head, and all I can remember is in November 1st, there was a discovery cutoff for the prosecution, but I can't remember anything after that.
You mean for the prosecution? Yeah.
Did I say that?
Is that what you said? Okay. Yeah. And then the defense. Then the defense was given the prosecution requested the defense be given a deadline, and then they asked for an extension.
Okay. On the criminal case.
Yes.
Okay. So
I'm like, wait, right?
I think so, because wasn't they asked for the extension on the 7th?
There was one extension was on the 7th, and the other one was on.
Okay, so the contempt thing, the deadline was apparently whatever it was, Monday or of this week. And then they asked for an extension relating to the documents from the lady in Texas.
Right.
Right. And then they also said we're continuing to investigate the 2 pounds of documents that got delivered to the AG's office. So there's that. But then, right, there was some sort of a deadline for the state to list everything. That was the document that you sent me. And we talked about at the very top of the show that they said we're in compliance with the witness list and exhibits, but they didn't list them out. That's on the criminal case.
Yes, that's in the criminal case.
And then the defense has a certain amount of time after that to respond. And didn't the court deny their motion for an extension of the discovery deadline? It doesn't matter. Okay, so they have some more time. Anyway, so the when the defense's exhibit list, when the defense's witness list is due, it's got to list all the experts. It's going to be pretty apparent who they've not only hired, have been given funds for, but who they're going to call to trial. It's going to be pretty apparent. And then the defense is entitled to whatever the state's experts relied on and vice versa. And so if they just relied on the discovery or the physical evidence or whatever, fine. But if they relied on medical records, mental health records, then the state's entitled to those anyway. And because we're in this stage of the process, if this had happened a year and a half ago, it could be a completely different thing. But once you serve your list of witnesses, including expert witnesses, the cat's pretty much out of the bag. Now, what the state would learn potentially is that if you requested funds for a tool mark expert to review the state's tool mark expert on the bullet, and a significant amount of money was done to do that, and there was an independent examination. They came in, so the state's going to even know that you've gotten money for an expert then, but you don't list that expert. That's going to tell the state that whoever you had look at it didn't give you enough information to come in and testify at trial. That doesn't mean, they didn't assist you with preparing for the cross-examination of the state's expert. But a lot of the strategy and whatnot is pretty much over. The cat's out of the bag once they file their list, whenever that's due.
Yeah. So I'm gonna wrap my questions up, and then we'll get to the chat questions. So listen, this came up because of Delphi, but I'm not talking about this case specifically, Travis. What I'm wondering, for a defense attorney, when you have experts, like Kara had said in one of her tweets, like the reason for the secrecy is if your expert comes to the same conclusion that the state's expert does, that just makes their case stronger. And you have item after item after item that kind of is more inculpatory than exculpatory. And at some point, as just a regular human being, you might start to question whether or not your client is actually guilty. So my question is there a line? Is there a point where if there's enough evidence in your personal mind, take your lawyer hat off for a second, and you're starting to really question your client's innocence, is there a moral line that meets with your ethical duties? And if there is, where do you go from there? Because I think a lot of people, even that are heavy defense, are thinking, what if, what if, what if? So, like, can you just explain what if? What if there is these confessions, which I take issue with the word confession because they were actually, said in court as admissions and incriminating statements, which may or may not be a confession. But regardless, there's confessions, there's this, the witnesses on the bridge, there's this, there's that. So where's the line personally and ethically for you guys when you come across something like this, where you might start to actually question your client's innocence? Are you just going to push ahead? Because it comes to mind because we have so many kids that are being murdered by men who should have been in jail. So are we, not in Richard Allen's case, but do we fight to set known guilty people free? Like, is
Right. So, but let me ask you one quick question. So when you said at what, it sounded like you were about to say at what level, what's the legal level or ethical level?
Mm-hmm. Like,
that
do you
you
ever
hit?
have those moral and ethical dilemmas, like as a father, as a husband, as when you question this man being freed because of your work? Is there a time where those two things dissect? And I did actually have a couple of questions from our friends that kind of went along with that same thing. Have you ever experienced that, where you've had to make this tough decision, or are you legally allowed to, ethically allowed to make a decision?
So I'm glad you asked that question, because there's a lot of confusion about that. Let me just say first that the attorney-client privilege, that privilege belongs to the client, and it survives death, unless you make arrangements for that, like Bob Motta's dad did on John Wayne Gacy in the tapes. But the attorney-client privilege is absolute, it's the strongest, stronger than mental health professional privilege, physician-patient privilege, priest-penitent privilege. It's absolute, and there are no circumstances, ethical, legal, moral, that it rises to a level that an attorney can betray or violate that privilege. It really doesn't happen. I never saw it when I was on a ethics panel, but an attorney that, on moral, ethical, whatever grounds, went to authorities and said, I just can't live with myself. He's told me this, and there's corroborating evidence, and he's really done it. So that just doesn't happen, except if you're Al Pacino and you're in a movie, and Justice for All, and you're representing a corrupt, sick, pedophile, rapist judge, and it makes for great Hollywood TV drama, but doesn't really happen in the real world.
When you
So
say that doesn't happen, sorry to interrupt you. When you say that doesn't happen, do you mean it doesn't come up where they say, I just can't do this? Or are you saying that the internal, like, what do I do?
I'm asking
Yeah,
more like yourself.
no, just wanting to clarify, privilege doesn't get violated no matter what. And then, but the first thing we need to talk about, the premise, the premise is wrong. So I don't handle any child cases, child sex crimes. Don't handle. I've handled a couple of sexual assault cases that were in the date rape scheme of things, and under special circumstances, but I don't handle those types of cases because, that causes problems for me. And so that's just my personal decision. And so I don't handle those at all. And, despite the fact that, we know a certain percentage of cases involving, I'm trying to think of words, won't get you a yellow light on this. We know a certain number of cases where there's allegations of inappropriate contact between an adult and a child are false. Most of those are in association with a custody battle. Not all, and these are cases that they were able to establish scientifically beyond a doubt that the child had made up a story, and nothing against the child. They were manipulated by adults into that belief. So we know that happens, and so I don't begrudge the attorneys that do that type of work. And if you take appointed cases, you really don't get to choose. That's part of the program. That's what you sign up for. You're going to get assigned an array of cases, and you take an oath that you swear to your God creator that you'll uphold, that you will zealously advocate on behalf of your client. The common question, I've seen it in this chat, criminality, all of them, and not sure where it comes from, but it's a widely held belief, or it's a question we get all the time from all levels, segments of society, and that is, how can you represent people that are guilty? And the corollary of that is, so number one, court-appointed attorneys like Rozzi and Baldwin, they don't get to choose who their clients are. They don't get to choose that they'll only represent innocent clients, and that goes along with how can you represent people to be guilty? And that's just that premise isn't a reality with criminal defense attorneys, because it's not the job of a criminal defense attorney, despite what people may think, it's not their job to get guilty people off. The job of a criminal defense attorney, most criminal defense attorneys never ask their client, did you do it? Because it creates a problem for them in doing what they're ethically and legally obligated to do on behalf of their client. It might impact them on the effort that they put forward. The job of a defense attorney, paid or unpaid, is to simply put the state to their burden, proof beyond a reasonable doubt, in the representation of a client that's presumed innocent. The defense attorney's job is to make the state prove their case beyond a reasonable doubt. Whether the client is guilty or innocent doesn't have anything to do with that mandate, with that function. Is the client getting a fair trial? Are they getting the counsel of choice? Were they, if there was a search, was it legal? Was it appropriate? Is the jury in this county, are they capable of being fair in order to give the client a fair trial? Or do we need to go to another county or bring people in from another county? So the premise of these types of questions is a false premise. Defense attorneys, for the most part, don't even ask the question. What's required is, and then when you get into plea negotiations, it's kind of a different thing. But so you have a duty to investigate independently. So you go out and investigate, you get the discovery, you look at what the state has, and then you look at alternative things like Saudi, some other dude did it, errors in the forensics, the DNA, yeah, that's the client's DNA, but that's from an innocent transfer, and there's an explanation for that. As rare as it happens, planting as rare, but unfortunately it does happen. Prosecutorial misconduct, like the Duke lacrosse team, Michael Morton in right here in my county, Williamson County. Those things happen. You investigate, do everything you possibly can. But as Bob has mentioned, we don't know. We weren't there. The prosecutor sure as hell wasn't there. The investigators are collecting information, other than a case that's caught on videotape or camera. Nobody knows. And so whether the client is innocent or guilty just doesn't enter into the equation. That's not the job under the United States system. In Europe, there's some collaborative systems, and in Latin America, where the components of the criminal justice system collaborate in order to try and seek the truth and find justice. But we have an adversarial system, and the main goal of the defense attorney is to put the state to their proof, make sure that they're doing it in a legal and ethical way. And the question on whether they're innocent or guilty just doesn't fit into that. And I'd be happy to answer more follow-up questions about that. It's one of philosophy. And so that's one of the reasons, I don't take those types of cases I mentioned at the beginning. Then I don't have to ask. It doesn't mean that the attorneys that do that type of work don't care whether somebody's really a perpetrator or not. It doesn't, regardless of the case, speeding, DWI, capital murder, kidnapping, these words are going to get us killed. These horrendous offenses involving individuals under a certain age, they're really, really tough and gripping. That one that happened down near Houston, for example, and we saw an interview of them, the parents or grandparents, whatever they were, of that little person. The person that's defending the individual who was apprehended on that appears there's very, very strong circumstantial evidence and statements by that person, a pretty strong case. The person that ends up being assigned to represent that individual, they're not going to be probably asking the ultimate question, did you do it or not? They're going to be reviewing all of the information. Was everything done in a proper and legal manner? And there just may not be, much of a defense for that person. But so to answer your question, respectfully, it doesn't contain, it's not a question that enters into the mind of a criminal defense attorney. And
I do understand that
if it did, you wouldn't be doing criminal defense.
Right. And I feel like that did clear it up for me. In my head, I was thinking, what if they see, discovery after the fact that's coming out and it's pointing to guilt? There's that line there. Whereas when you're first kind of, assigned the case or whatever, you're reviewing all the evidence that there is and advising your client from that point. So if there's evidence of guilt at the beginning, then you might advise them differently than going on this whole, journey that these, because I've always said, and I truly believe that Rosie and Baldwin truly believe that Richard Allen is innocent. Otherwise they wouldn't be doing all the stuff that they're doing. But it really made me wonder after, we start hearing certain things and I just wonder how that information would affect a defense lawyer's sense of morality and community and everything else that goes along with being a human being, taking away from their position as a lawyer. It made me wonder, as a father, as a husband, would you want some monster roaming the countryside, But I understand what you're saying. I get it.
Yeah, it doesn't play at all because if the state's doing their job, then nobody needs to worry about it. But some of these cases. Oh, go ahead.
I'm just saying I totally agree with that. That's what I always think is, if the state does their job, then it's fine. It's like, it always bothers me when people talk about like defense attorneys getting their clients off on a technicality. No, the state didn't prove their case, or they thought they did, but they didn't follow the correct procedure. That's on them.
Yeah, technicality is typically a constitutional violation.
Which is huge. It's not a tiny technicality.
Yeah. So the it really doesn't factor in. But what people don't realize also too is most cases, 95% of the cases, it's not really a question about whether the client is guilty or innocent. It's really what the question is what's the appropriate thing for that conduct? What punishment for that crime? And, is it jail, prison, programs? And these are, major public policy things. In Texas, sometimes the only issue is whether they should be getting the death penalty or they should be getting life without parole. Sometimes the issue is like most of the cases I handle, the question is justification, legal justification, which is self-defense, and whether, for example, whether it was appropriate for a peace officer to use a certain level of force given the circumstances he or she was under. And so in the law, when you have a defense of justification like self-defense, you're pretty much acknowledging that the elements exist for that homicide. So there's no question which officer fired. There's no question that it was from a firearm. No question it was deadly force. No question that the officer was intending to hit the person. The question is whether it was legally justified. And so there's not that type of thing, but that category of cases, the book that doesn't answer all of it, but discusses all of it, and raises these questions. And you gotta read To Kill a Mockingbird, and you gotta watch the movie with what's his name, Gregory Peck, and that's where it. What
wasn't Sissy Spacek the little girl?
No, maybe in a remake. I'm talking the black and white.
She read the audiobook, sorry.
Okay. But that's why that book set Nell Harper Lee up for life. And it asks these very difficult questions, not only, so here, in that part of the country, and nobody's standing in that person's corner. I just saw a great movie. What was it? Where the Crawfish Sing. Has anyone seen that?
No, never heard of it.
Where the Crawfish Sing, and it's about
the movie.
Girl. Huh?
I saw the movie. It was a book originally, but
yeah.
I saw the movie.
Yeah. Was it on Netflix or Hulu? I can't remember. Anyway.
I can't remember.
So the dilemma of an unpopular person being tried for the unaliving of a romantic interest, and I'm not going to give anything away on it, but you need to see it. And, you know, old time attorney comes in and, you know, what, and he's just doing a great job of poking holes in the state's case. And, you know, there's a couple of real dramatic twists and turns in it that, you know, I think everybody would enjoy, but I won't give away. But, you know, these things people wonder about. And, you know, there's some prominent attorneys that get more into it that, you know, we see talk at seminars, and, you know, some are like, well, if I could just explain how your fingerprint might have got left on the counter at the bank teller, I can pretty much handle this case, meaning they're in essence offering their client a way out if they can somehow come up with a logical explanation for it. You know, I don't think there's many of us that do that. Look at the evidence, and you know, once you get all of that, it's like, well, they got a pretty compelling case. You know, do you have some explanation that would have, you know, and then listing all of these things that they have, and then, you know, pretty much the only cases that are going to go to trial in that situation are ones where the state is the only offer is life without parole, and there's no death penalty possibility, and so there's no way to plea bargain them, and they have to go to trial. And so somebody's got to stand up on behalf of that defendant and make sure the state does it the right way. But, you know, it's in every profession. The key difference is with attorneys in criminal defense, if you take appointed cases or you work in the public defender's office, you're not given a choice. And then, you know, back in the old days, a federal judge could call me up and say, I need you to represent so-and-so.
Really?
I'll pay you, but you're going to handle it. No, I'm not going to, you know, you're going to handle it. I'm not, oh, you're going to handle it. And okay, you know, so now the motivation, you know, again, these are philosophical questions. So in a perfect world, you have this hypothetical defense attorney, him or her, and the defense, you should not, in a perfect world, be able to tell the difference between the defense they provide on behalf of a multi-billionaire versus the type of defense that they provide for somebody that has no money. And you also, and the fact of the matter is there's a huge disparity between the defense for people that have significant money versus indigent. And then you shouldn't, yeah, and you shouldn't be able to tell the difference between a defendant that, you know, let's say there's DNA and, you know, it's just absolutely clear. I mean, there's just no other explanation that that person committed the offense. In other words, looking at the motivation and the vigorousness of the defense, the quality of the defense, it shouldn't differ between a defendant that hypothetical attorney represents, where there's serious questions, and one that they're are, there's really no question. It should be just as vigorous. You might be more limited in what you can do, but you should be attacking the search and attacking the confession, if there is one, attacking the scientific evidence on, whatever you can in good faith attack. But I don't know, because I don't ask the question, and most of my cases are whether a legitimate justification defense exists. I have the luxury, my cases, I firmly believe there's justification. Public defense. Go ahead.
No, please finish.
Public defenders, I don't want to call it a luxury. They don't get the choice, but there's a lot of folks. The question, how can you defend guilty people? That's usually presented to attorneys that have retained clients like Garagos and get huge fees. And how can you defend guilty people or people who are guilty? And we're taught that from law school on, that if you're going to represent criminal defendants, whether they have money or not,
right,
then you have to firmly believe that upholding individual rights is paramount, and that justice is served for everyone if you require the other side, the state, to prove their case beyond a reasonable doubt. Now, other professions, like Ivy can talk about, there may be like licensed psychologists, for example, that they can't work inside a prison setting trying to do whatever on behalf of being a staff psychologist in a prison, or
you mean for like moral reasons?
No, not moral, more just that it wears on them, or
I could never work with people who have histories of animal abuse. I just mentally would not be able to do it. And
right.
most
I have a
therapists
friend that,
and psychologists have their line of like who they just can't do.
Yeah, I mean, I have a friend that worked on Rikers Island as a psychiatrist.
I can't imagine.
For a year and a half, and it almost made her leave the field completely.
Mm-hmm.
So, if you don't mind, I know you're talking some hypotheticals there. Joan has a question. It says, Mr. Travis, at what point, specifically talking about Delphi, I assume, would the state have to say if they're seeking the death penalty, where he has requested a speedy trial? Does that mean the clock is running out?
I would think so. So I remember asking that question the first time I was ever on this channel, and knew nothing about it. The case, was trying to figure out where it was at, and trying to reconcile all the outrage about what had happened, what that community had been through. And then I'm like, well, have they requested the death penalty? If not, why not? And then, is the community outraged about it? And, I understand and even knew then that while Indiana has the death penalty, it rarely gets carried out. But I was surprised in this case, because it's eligible for death penalty and eligible also for life without parole, that certain things weren't being filed, because having death penalty on the table significantly increases the chance of a plea bargain being worked out. I could never find out the answer. when I was in the chat in Defense Diaries, Bob Mata, when they had the Indiana defense attorneys on Kara, and then, which was mostly about the original action, but what's the name of that younger attorney that's a public defender that Bob
Shay
has?
Hughes.
What is it?
Shay Hughes.
Yeah, Shane or Shay?
Shay.
Shay.
Shay. Shay didn't know exactly the answer either, but he doesn't handle death penalty, I don't think. It's either expired or run out. I think, I would think in the next 10 to 14 days, if they're going to be seeking the death penalty, there's got to be a notice within the next 10 days to 2 weeks. Yes, it is running out.
All right. Thank you. The next question we have, Wonder Girl asked, and I'm sorry for everyone, like a couple of these questions are from like an hour or 2 hours.
Oh man, I'm so sorry.
Oh no, you're okay. We don't have very many. But Wonder Girl asked,
I don't care how many there are. I got nothing to do. It's only 10:30.
Travis, do you think the defense will end up withdrawing the 70-day speedy trial? My understanding is they can do that anytime they want up until trial.
I don't think they're going to withdraw it. And
But legally they can?
Well, legally they can withdraw it, or they can, if they file a motion to disqualify, or they file some other type of motion that's going to delay things, then
Right.
That's going to trigger automatic delay. If they file a motion to disqualify, pretty much the 70-day is out. So I don't think they're going to withdraw it. I think they believe that they have the state still on their hind foot, as it was expressed in the oral arguments in the Indiana Supreme Court. Not nearly as much as they did on end of October, early November, but that they still have them behind the 8 ball, and so they're going to press forward on that. And then, but they can do it. I don't think they will. Let's see. Do you think the defense will end up withdrawing 70-day? No, my understanding is they can do that anytime up until trial. I think they would be hard pressed, because a lot of things are going to have to happen to get that thing scheduled to start on or before May 15th. A lot of money is going to have to be spent. A lot of preparations are going to have to be made. Court security, ample staffing, transportation, moving him from the prison to the county jail, because you're going to have to keep him in the county jail at that point. He's 4 hours away, right? By car?
I can't remember at this point. It's like from which place?
From where the trial's going to be.
I think it's 4. I think it's 4 hours. I could be wrong though.
So they're going to have to bring him into a facility that's nearby the courthouse, which is going to be
Carroll County Jail.
Carroll County, but jurors are going to be bussed in from Allen County.
Yes.
So,
and we don't know yet if they'll be sequestered or not.
So the more those pieces get put into place and set, there's going to be a point of no return where even if they wanted to withdraw it, the court would say, no, you wanted the early trial, we're going.
Okay. Before I go to the next question, Charmaine or Ivy, do you have any questions or anything to say?
Yeah, but I forgot it. So go to the next one and I'll catch him.
Yeah, and that's another case I won't handle, is animal cruelty.
There should only be one punishment for that.
I can't think of
Sweet.
any questions right now because I'm afraid I'm gonna just get on a soapbox,
I
but
don't know.
some will pop up on my head.
There was
Popped up
one
on my
actually that Deb had more for Ivy, Aspen, and Chat. So we know that Kagan Klein was transferred. And
Oh,
Deb,
yeah.
let me just pull it up here. Deb said,
She's
I
such a
don't know if this
troublemaker.
is a question for Travis, but I'm curious as to why people think Kagan was moved again. And the second part of that is why would they have him in protective custody?
On who?
Kagan Klein.
I just saw it in passing. I don't really know any of the details, to be honest.
Yeah, no, me
I mean-
either. He's loosely connected to Delphi. Not really, sort of.
But who was moved?
Kegan Klein. He was the one that was who was a lot of people were attributing guilt with his crime. Who was responsible for the CSAM? He's the big guy. He got sentenced to I think he's serving like 24 years. But yeah, so a lot of people think there might still be a connection to him in this case. And he got transferred the same day as the Speedy trial, or the day before. Actually, I think he was transferred February 20th. I can't remember.
Is he the one in the CW presentation that he was convicted on?
The CP.
Younger kids in inappropriate poses. Yeah. Okay. No telling. I know nothing about it, but my utter speculation would be it has absolutely nothing to do with this case, and it's pure coincidence, and that people get moved around for all kinds of reasons.
Right.
The typical reasons are security or disciplinary problems, so they get moved to a higher level environment, or they're doing really well, so they get moved to a less secure environment, or that type of offense. There are some treatment programs that are at particular facilities, and unfortunately, the programs at those facilities are usually all full up, and then you got to wait for someone either to be released or pass away or whatever. And so once the spot gets opened up, they get moved to a facility because they have a treatment program for that particular type of offense. But I don't think you can really say. I don't know if Ivy or anyone else on the panel has any thoughts on it, but they would have probably more informed thoughts than I would.
I don't.
I don't think
I
know.
think
I have no thoughts on it.
I think what I heard was that, and I'm not saying this is true, I just saw this in a chat, I believe is where I saw it, that he was moved, and he was just moved like fairly recently, so moved again, and then that the time he had left to serve went down. But again, I have not looked for myself, no idea.
Yeah, and I can answer that one. Is his sentence has not changed. It's the reason that the sentence, I think, and I might be getting, I think it was 47 years, 48 years.
I don't know.
But with the way the Indiana 1 day, 2 day thing works, is he was going to end up serving, like his release date was always going to be, I think, 2048, I think. And that hasn't changed. So when people are looking at he was sentenced to 40 some years, but his release date is 2040 something. It's because of the way Indiana does their sentencing with like 1 day served for one, and he's already technically been in custody for 5 years because he got arrested. Not 5 years. He got arrested in 2020, I think.
Yes, August, I think.
Yeah. So he's already served almost 4 years of his sentence. So his sentence has not changed. Next,
let's see. Lone Pony. That's my understanding and my experience. Fortunately, I had very, very few clients that were in prison, but in working, helping on post-conviction and seeing things, that I concur with that, absolutely. And then what was the question before that? Is Nick, it was more of
I'm
a
gonna pull it back
statement.
up.
Oh,
Okay.
I was commenting, and then
It's-
I wasn't listening to the last question. I don't think. What do you think it was?
What?
The last question that that Travis was just asking.
The last question that was up on screen was, do you think McClellan, this was up before the last one.
Oh, okay.
We haven't gotten to it yet, though. Do you think McClellan regrets pushing this contempt hearing?
Oh, I remember my question now.
I don't, well, I think they've kicked it into overdrive with lead pipes, Hennessy, lead pipes, list of exhibits and witnesses. They, as we mentioned earlier on, there's some things in there that, may not turn out to be too concerning whatsoever, but there are a couple of things in there that I know is going to be causing the state to have to be thinking about a lot of things. So, I don't even know what would happen if he said the state moves to drop the motion for contempt. I think it was a motion for contempt, and they didn't set it into a new case. It's part of the Richard Allen criminal case, and people have talked about that on both sides. Some pretty knowledgeable people, including Michael, who I nicknamed Footnote, who's from the Indiana University School of Law, runs the federal habeas program, and then as well as Hennessy filing a brief saying, they really needed to file this as a new case. They listed their reasons, wasn't done. Obviously, the judge didn't agree with it, so some sort of a hearing is going to proceed, unless the DA files, a motion to withdraw that motion before the 18th. And I don't know that she would drop it. She might just take it over sua sponte. That's what's so confusing about this contempt thing, and why it wasn't, if it's direct contempt, the judge just handles it, and right then and there, because it's conduct that occurs in front of the judge. But if it's indirect, then it's conduct that the judge doesn't witness, like letting documents that are covered under a protective order or a gag order get disseminated in violation of those orders. Judge didn't see that firsthand, so it's indirect. It can be civil or criminal. Civil is generally to get lawyers or parties to comply. Somebody doesn't pay their child support, and they have the means and the money to pay the child support. So the judge puts them in jail until they agree to write the check, and they don't get out of jail until they write the check. So the jail or the fine isn't for punishment, it's to get them to comply with the court order. And then criminal contempt is, in essence, somebody's willfully and intentionally violated a court order and they need to be punished. That's what we think is going to happen on the 18th. They asked for clarification, saying that normally if it's criminal contempt, the DA presents it, but it's supposed to be filed as a new action, new case number. That hasn't happened. So a lot's up in the air. And with like all things, just this case is a perfect example. Hennessy came in the day of this hearing, where there was the in chambers, backdoor session. Baldwin apparently made an oral motion to withdraw, and ended up in that whole debacle, which basically set the case back at least 60 days, probably closer to 90. And they, the Hennessy tried to tell her, he filed a brief, didn't really let him say anything that day, whatever it was. And they came back on the 31st, and she did let Hennessy speak, and he laid out what the law is, why, in the way he's supposed to, respectfully, and lay out the law. And respectfully, Your Honor, you don't have the jurisdiction to do this. If you do it, it's structural error, and we're going to be right back here and ask you to reconsider in light of them agreeing to be retained counsel on a pro bono basis. And she let him finish saying everything, and said thank you, denied. She addressed Mr. Allen and said, there's just no way I can let your attorneys represent you, and blah, blah, blah. And boom, we're back. Everything that Hennessy had in his brief and everything Hennessy told the judge on those 2 days, mid-October and October 31st, was essentially 100% accurate and right down the line with the way the court explained in their detailed opinion. But all of us, for better or worse, and to some degree or another, get locked into opinions and viewpoints, and we become unreceptive to other viewpoints and other sides of things. Judges aren't supposed to, but they're human. And so whether the DA is worried about anything, I kind of doubt it, but there's a few documents on there that I think would cause most normal DAs to be telling people, okay, I need you to check out this, and what's going on with this and what's going on with that, and getting particular investigators or detectives that looked into the office to find out what's going on here. And so they may do that, and they could withdraw it. They could say, after further investigation, we don't believe we're going to be able to prove it was intentional or willful, or we don't believe we're going to be able to prove the conduct is on these two particular individuals. Who knows? But absent something like that, I don't think it's going to phase them. I don't think worried, but I would be about a couple of those documents. Most of them, no. Most of them is about the stuff related to the drama between various content creators, which is still something, I just really can't understand
Weird.
See,
Yeah,
so,
why it's even.
Can I ask a real quick question? You said willful, and there's another word that goes with that, that in order to be guilty of the criminal contempt, the behavior has to be like willful. If there's a protective order, let's say, I don't know exactly how it's written in that one, but let's say that part of that is that you have to keep the discovery in a place that's like locked up and whatnot, and you don't keep it locked up, so it'd be willful. You made the choice to not lock it up, which led to it being disseminated. So even though it wasn't willfully disseminated, you willfully left the like door unlocked or whatever. Does that count as willful, or would that still be under like accidental type of thing?
let's see. I think it's knowingly and willful.
Yeah, knowingly and willful.
But now the protective order in Westerman was way better written than the one that exists in this case, the Richard Allen case. Does it say in the Richard Allen protective order that need to keep it in a locked place?
I don't think so, but just like hypothetically.
Okay,
Would
so
that
yeah,
count
that
as-
could be a form of, in certain cases, not doing something is knowingly and willful. And the most common example of that is care of a child or elderly person. And, they develop bed sores or they, malnourished. And you're not willfully and knowingly doing something. It's your failure to do something. Make sure they turn over. I don't know what the deal is. I know if you don't make sure that you're doing something right, you're going to get bed sores, and there's a protocol for that needs to be followed. And not doing it is tantamount to intentional and knowing. If you don't do that, you know what's going to happen. Just like if you don't feed your animals or you don't feed your kids, that's intentional and knowing. And the law provides for that. It says, where you have a special relationship, you're caring for an elderly person, your children, there's a special relationship. And so intent can be shown by omission. So there's specific categories and it's specifically for those. Otherwise, you've got to show that they knew the order was in place and that they did things that specifically to violate that really that they handed that material over to somebody that it should not have been handed over to. If the order had said, you need to have it in, in a locked place and something like that, and that's going to make it easier to get over that hump, Ivy, is, you didn't have it in a locked place. You didn't have it password protected. You didn't have a screensaver that came on with a password lock screensaver that came on within 10 seconds of no activity or, whatever, I don't know. But if that had been listed out in the protective order and those things weren't implemented, it's going to be much easier to show whatever those exact words. It's not intent, willfully and knowingly, I think.
Okay, that's helpful.
So CJK has, I think, a fairly quick question for you to answer, and then there's a couple of people want to know what your opinion is on the ballistics. But first, CJK just wants to know what made you want to become a lawyer.
Yeah. I wanted to be a lawyer since the 7th grade, and it was a combination of things. I grew up in the Bay Area, San Francisco Bay Area, and my parents, especially my father, he was an engineer and, worked in the space program and high-tech stuff. And, but my dad always seemed to have a sense of justice and looking out for the underdog. So, every once in a while, he'd pack all of us up to become involved in, some sort of social issue and doing a demonstration, whether it was attending a rally in Golden Gate Park or being part of a march or rally. So, one of those things was that we did that I remember. We went out and marched with Cesar Chavez and the farm workers. And then another thing we did is he told us about this woman who let a nephew stay in her house. Her nephew stole her a firearm she had, a legal firearm that she kept in her house. And he went up to a courthouse in Marin County and shot the judge, killed him, and helped a couple of people escape. And that they arrested this woman, and they were trying to raise money for her because she didn't have any money to hire a lawyer on her own. So I was part of this campaign to raise money, and I can't remember exactly what I did, but I raised $300-400, and my dad took me down to the place in the South Bay Area to drop off the money. And I got to talk to all these people. It turned out to be huge lawyers in the Bay Area, including we had a family friend, Tony Serra. You can look him up. There was a movie made about him. Really didn't do him justice, but if you Google or YouTube Tony Serra and what he's all about, he was a family friend of my father's. But that woman that had been imprisoned and went to trial and was eventually found not guilty. And my dad took me to a couple of days of that trial. Her name is Angela Davis. And some of you may not know that name. Some of you may never have heard of her. But
Sounds familiar.
What's that?
It sounds familiar.
Yeah. So Angela Davis was a professor in the University of California system, and was sympathetic to the Black Panther Party, which was based in Oakland. And they what the state was trying to allege is that she furnished the weapon and was part of the planning of that. But anyway, so I wanted to be a lawyer, not necessarily criminal defense. I really didn't even know everything lawyers did. But when I saw what the lawyers were doing for these different people and what my dad was trying to teach me, it just instilled in me a sense of justice. And So I just kept going in that direction. And then, like the Talking Heads song, one day you find yourself here, and here I am.
Right.
So
I just looked up Tony Serra. I'm going to read all about him tonight. He seems fascinating.
I'm trying to remember his movie. It was played by James Woods, and
True Believer.
Yeah. And but I mean, Tony Serra is another lead pipe carrying MFer like Hennessy.
I'm going to move on to Carol's next question if no one else has a question. But Carol says, so what about those cases where it's caught on camera? Is defense still required? I think that's related to when you were talking about the hypothetical stuff earlier.
Yeah, defense is still required because, and frankly, if it's caught on camera and the jury doesn't determine punishment in that state, the case isn't going to go to trial. Or if the client insists, so there's 4 things only a client can do. One is enter a plea of guilty or not, because they have a constitutional right to go to trial. And every once in a while, they're caught on camera, red-handed, and no, I want to go to trial. That's not me. And okay, I've shown it to your mom. I've shown it to this hadn't happened to me. I'm, hypothetically, I've shown it to your mom. I've shown it to your dad. They say it's you. Who can I call as a witness that will back you up on that? Or, are we going to have, you're going to get up there and say, that's not me. And, if that's what they want to do, that's what they want to do. But as, realistically, most plea, if you go to the judge for punishment. In Texas, you have the option. You have the option to go to either the jury for punishment or waive jury on punishment. You go to the judge. Under certain types of crimes, certain circumstances, only a jury can give you probation. And so they'll insist upon a jury trial. And it's really more on the punishment, trying to get something better than what the state's doing. But that's a great question, Carol. The reality is you're probably not going to have a trial unless something, they're caught on camera and the state's demanding the death penalty. You just have no choice but to go to trial on it.
Okay, Miranda Lee says, has Travis had a client flat out admit they were guilty? And if so, what was the worst charge?
I've had numerous admit that that's me firing a gun that ended up killing the person who was a criminal suspect. So they admitted that they committed the offense of some level of criminal homicide, whether that's murder, manslaughter, or criminally negligent homicide. Those are our 3 levels in Texas. But the question wasn't whether they pulled the trigger or not. The question was whether they were justified. So the worst charge has been murder. but I don't think that's what she's really asking. And I don't, the aside from that, the worst case where the person admitted, yeah, that's me, and was a case where a boyfriend shot through a door.
Oh, like the Olympian guy.
Oh, no. So he's outside an apartment door and fires through the door down, and in a fluke, it ends up striking her inside around the area of her kidney, and she bled out. And so the question was, what was the level of the offense? What should it be, murder or manslaughter? And the state wanted either 99 years or life, and I was trying, younger man, I was trying to get him around 25, but they wouldn't hear anything about it, and then the jury gave him 20. And
now have you ever had a client tell you privately that they were guilty, but they wanted you to present a completely innocent defense? Or is that against it?
No, because I don't give them an opportunity when they start to say, I want you to know, Mr. William. I mean, I said, stop. Doesn't matter to me. When the time's appropriate, when I know what they have, I will get with you, and then, we'll do the investigation. And I don't want to know anything about whether you did it or not. That's not my job to prove that innocent people are innocent. It's the state's job to prove that you're guilty beyond a reasonable doubt. And then I'll look at everything, we'll investigate, and then we'll determine, whether there's reasonable doubt in their case. And if there is, we'll focus on if there's other areas that need to be explored that also raise reasonable doubt. Or if there isn't any reasonable doubt from their case, we'll start to look at, is there anything else? But so, for example, there are false confession cases, and especially with juveniles and people with lower IQ and problems with susceptibility, and there's psychological scales. But the Reed technique that's used all over the US, there's warnings in there. Don't use it on elderly people, don't use it on juveniles, don't use it on people that have issues. And so you get these false confessions, and that's one of the things in the Avery case. No matter which side of the thing you're on, the attorney initially for the young man, Brendan Dassey, what was so infuriating to people is that there was this false confession. The attorney didn't know enough about the fact that there are false confessions. The DNA exoneration data bank is full of people who've been convicted, of people who confessed, and that doesn't mean anything. And he thought his job, that attorney, was to get his client to confess again and give that information to the state, and and work out a deal for 10 or 20 years in prison, and then he would be a hero. The problem being that this had all of the earmarks of a false confession, and he should have been exploring that. He should have been investigating that. He should have been asking for experts to evaluate that. But he didn't understand what a criminal defense attorney is. For some strange reason, it may be because he has a background in military law. And when you work for the JAG, some days they assign you to prosecute cases, and some days when you're a JAG, they decide they have you defend cases. So you're back and forth all the time. I know it's crazy, but somehow he didn't learn that in civilian world, one job of a defense attorney. So he confused that, thought he would be a hero by working out a plea for him for 10 to 20 years, and just terrible thing. And so that's the problem when you don't understand what your role is. I answered that right. The most serious case was had other cases where it looked pretty apparent. For example, a DWI case, the person blew 3 times the legal limit, but I got a not guilty because I was able to raise doubt about the tests, about the stop, about everything the police were supposed to do. The state, between the police and the prosecutor, didn't do their jobs. The jury found them not guilty. But again, going back to what we discussed at the top, this stuff just doesn't really come up. We don't really ask our clients if they're guilty or innocent. Did you do it? And if they start to tell us, we stop them and explain what the government's job is and what our job is. So the stuff on TV, it just doesn't really happen. To get a better idea of it, it's just these extreme cases, but there's something out currently now, American Nightmare on Netflix, about a couple in their apartment. And there's a kidnapping, and I won't give it all away, but for some reason, the police don't believe their version and think they're making it up. And the ride they go through, and they didn't have an attorney during the investigation process. They should have had an attorney later, but it was an American nightmare that they went through. So there's a few cases where
I saw that one. Sorry.
Yeah. But things about polygraphing and the FBI agent being romantically involved with another person involved in the thing, and the FBI not thinking that's a conflict.
Right.
Crazy stuff. Yeah.
Lone Pony says, "Thank
no,
you,
I
Travis."
haven't had something worthy of TV or movie drama
Yet.
Lone
Pony says, "Thank you, Travis, for your priceless insight. I've learned a lot this evening. Sonny, please don't fire Charmaine. LOL."
Thank you. I appreciated your comment about segregation, etc. I think right on point.
Right. And thank you, Lone Pony, for the donation. That way Sunny will be like, oh no, I just won't be here more often. And then Charmaine and I can actually do the show responsibly, like it should be done.
Yeah, we can do a show on making Bloody Marys and Caesars.
Charmaine will
I think that's a good
have to
idea.
give
I
us
had
the
one
tutorial
king-
on Caesars.
I've got one king can of Caesars, and I'm half blitzed.
And I can teach everybody to make the perfect martini.
Okay, I have a quick question.
I thought the perfect martini was any martini I didn't have to make.
Oh, that's funny.
That's a pretty good one. But I think you'd like mine.
I like them really
I have
dirty.
a question, and I don't know
Right.
if it's quick or not, but I would like to know why Travis thinks the contempt hearing is happening now. Like, why now? Why is this not something that could wait until after the trial is done? Like, do you have any suspicions or any, I guess, guesses about what might happen on the 18th?
So, okay, on why now, the full opinion came out whenever, late January, early February, whatever.
20.
When? So in that full opinion,
Okay,
you
Charmaine.
read it, and I think Kara, either on Defense Diaries Live with Bob or somewhere else, mentioned that, she was disappointed with the opinion in several respects. And I think one of them is, in that opinion, they pretty much invite the state to file the contempt. And so I'm not sure what's going on with that, but that's why they gave a green light, open door to filing contempt. They didn't say what they saw was contempt or not, but my reading of that opinion was that they were giving a thumbs up, green light to file contempt. And then that motion happened within a reasonable amount of time after that. And, here we are. I have no idea what's going to happen on the 18th. And nobody else does either.
Oh wait,
We just don't know.
Nick McClelland didn't call you and tell you?
No. Now, he did not call me and tell me, but
You're just not
hypothetically,
amazing.
if he had, he also told me to delete everything. So
Of course he did.
Wow.
So
I've got
you
my
don't have any
possible
guesses?
deniability.
You don't have
I'm
any
sorry?
guesses? That's not something that you're willing to do?
I'm not even willing to venture that there's going to be a hearing, even though, they're transporting him. And, what I've heard's transpired at previous hearings going back into the summer, and that there being a transcript from last summer. I don't know what that hearing was about, but they're trying to get that. But what normally happens in a hearing anywhere else, federal court, I've been in federal court in a number of states, state courts, mostly Texas and Nevada, but California, Idaho, others. The hearings that you see with the Idaho 4, and you got that camera, and there's the state, you got, normally the judge is on a bench, but with the way things have been, they're all on video, and the judge is out of town, so he's from doing it via remote. But one side talks, then the other. Whoever's bringing the motion argues last. They get to go first and last. Judge might have some questions. That's how hearings go. From my understanding, there really hasn't been one of those. People who have attended these hearings really hasn't been a hearing. So I'm not certain there's even going to be a hearing. So the history of that court and how things get handled, that one thing's for certain, they know if they want the judge, if the judge wants to hold them in contempt, there has to be a hearing. So they know that. So maybe that's why there's a hearing. So maybe there will be a hearing. We don't know what the evidence is going to be.
Right.
Exhibits have been listed. That doesn't mean they're even going to be offered. They have to be listed, or
right. And they held depositions. I mean,
Yeah.
I think there will be a hearing. I mean, I don't think they would have gone to the trouble of holding a full day of depositions. I mean, I basically think, what the 18th is going to turn out to be is, basically what the 19th of October was originally going to be had they not resigned. But who knows?
Yeah.
I don't know how they're going to.
Okay,
I mean,
I
there's
got a
no way
question.
they'll get all of those witnesses in, and do the amended charges and do the motion to dismiss all in one day. So I doubt all of those witnesses are going to be called.
So Aspen,
The motion to amend the charges should
10 minutes.
that 15 minutes max. The motion to dismiss for the destruction of evidence, that's 10-15 minutes. Figure half hour per witness. I don't know how many witnesses got, 5, 6. That's 3-4 hours of testimony.
And then 5 or 6 on the defense side too.
Oh, okay. Well, just because they're listed by either side doesn't mean they have anything relevant or pertinent to testify to. Obviously, the investigator, whoever, if that was Holman and anybody else that went and talked to these individuals, I don't know. And I don't want to say that person's name, but the airman, I kind of figured without reading or knowing anything that this guy, that when McClellan is discussing what the investigator has been doing to track stuff down, we're reading between the lines. It sounded to me like he was out threatening people, super serious, and threatening them with jail and 180 days in jail, and which is, what some investigators do. That's their style, and especially trying to grab stuff before it gets out further, and trying to intimidate people to giving up stuff that if they had a lawyer advising them, they just say, have them call me and tell them you turned it over to me and have them contact me, which I've had happen numerous times. And then I look at what it is and advise my client, look, you really need to return it. I can try and prevent it. I've had all kinds of cases about that, where there was like a computer hard drive with a list of clients, and contacts that, elected officials did not want that hard drive getting out as part of a divorce case. Anyway, I won't get into that, but so I heard there, was all these threats against that individual, and then, but I don't know. And then ultimately, he did what he did. I don't know. I would think the DA, if this thing goes forward and we start hearing witnesses, is going to want that in there, and that somehow, and this is why it deserves the punishment that he's going to be asking for, that going to be trying to make the argument that Baldwin for certain, and Rosie, I don't know how he ties him into it, but whatever, is somehow responsible for the death of the unliving of that particular person, which he can try, but I'm not sure how much there is going to be of that, but Hennessy will be ready for it. And, that would really be a great one to be watching. And it's going to be interesting to hear how things go, if they call these witnesses, if the judge is going to allow any testimony about that. But I know Hennessy is going to be able to handle that, and will be able to show if it's anybody's fault, it's the investigator, and how he handled that situation with that person. And a lot of different stuff, but going to be fun.
Okay, so good night, Lacey. Ivy has one last question, and then we'll wrap it up, if that's okay with everybody. And I
I've got a
believe that,
few more chat questions, but they're not long ones.
okay.
Yeah, I'll answer them quick. You want to do those real quick, or you want to do Ivy's?
No, let's do Ivy's.
Okay. She wants to know, what does Travis think will happen if Gull sanctions BNR in regard to the Osbrooks claim that it would violate Rick's 6th Amendment? Or
Apparently it's 6th and 14th.
okay, will there be an original action, since he basically threatened to do one since she basically threatened to do one if she sanctioned them without the separate charges of criminal contempt?
Okay, so that's footnote 1 and footnote 2, right?
Yes, good memory.
Yeah, I love those footnotes. Filing that writ, that's more of a stretch, and he acknowledges that, I think, in footnote 2, that conceivably, if it reached a certain level, he cites one case, says that could be an avenue, and I don't think that one's very likely, because it's very, very difficult to do unless some specific things occur in the hearing, which I don't think is going to happen. I do think, setting that stuff up on jurisdiction, that if they didn't do a separate case, that they will, if she orders some sort of punishment other than like a nominal fine, they'll file they'll do what he says he's going to do in footnote 1.
Okay, so you think it will happen if it's anything more than a small fine?
Yes, unless they find out something different, the state comes forward with something that says, "Oh, well, here's this case that you didn't cite that says I can do it this way," or I take that lawyer Michael footnote at his word. I think there's a high likelihood of that. Except now, you guys, all three of you, make me think too hard, especially on a Saturday. Okay, but now they've got a speedy trial, right? And so if doing what he said he's going to do in footnote 1 jeopardizes that speedy trial, which is why it's supposed to be a separate case. But because it's part of the same case, by filing an appeal, if it was a separate case, it wouldn't jeopardize the 70 days at all. All it jeopardizes is whether they got to do jail time or pay, a hefty fine. But because it's part of the same case, if the avenue is to pursue an appeal in the Court of Appeals and they got to get certification for it, that stays the case. It's going to impact the 70 days. So I suspect the first order of business in that hearing on the 18th is going to be, if they're going to try, don't know how much time the court's going to give it, but I think one of the first orders of business is going to be that the way the DA did it is wrong, and it should be dismissed and filed as a separate action. And they're going to be fighting hard on that because if they don't win on that and they are given jail time or enough of a fine to where they want to appeal it, then they're not going to be able to bring the interlocutory appeal. They're going to have to wait and appeal it until after the case is over, after the trial, because they can't jeopardize the 70 days.
It seems like such a simple thing that could have been done. It kind of makes me, this is probably very much wishful thinking, but it kind of makes me wonder if maybe Goal has a plan of not sanctioning them and just giving them like a good talking to, and then saying, well, but because this isn't a criminal, whatever, so she gets the talking to saying you did wrong out, and then everybody just moves on. But that's probably wishful thinking. So, well, I don't know.
It's actually, if things were under normal circumstances and it didn't have this baggage and history, and regardless of what side you're on with Goal, what side you are on with Baldwin and Rosie, whatever, what side you're on, I would agree with you 100%, but it's just an unknown. If this exact same thing had happened in Texas without all this baggage, what do you think is going to happen? I'd say they're going to get a good talking to. It's going to be on the record, and going to give a opportunity for the attorneys to apologize, purge the contempt, and then everybody's going to carry on and move on and act in a professional manner. And they're going to be damn careful about leaving that stuff out. And, they're going to take them at the word for locking the stuff up. But that didn't happen. The attorneys got removed. That's what Hennessy Lead Pipe was trying to do, trying to get it back into perspective, explain, why you can't do that. And, judge, not condoning what they did, not condoning what they allowed to happen. But my brief points out what measure this isn't going to happen again. But it didn't. It's like, I'm removing them. And so we saw how that turned out. And so I'm skeptical also, Ivy, but all things being equal, it would have typically turned out in the courts I've been in front of, state or federal, exactly the way you just said.
Well, hopefully it
It'd
will.
be a lot of finger wagging. Anybody watch Boston Legal?
Mm-mm.
Yeah. It's on reruns somewhere. One of your favorite platforms. Watch it. It's great. Just a few episodes and the judges. Jibber jabber. But Artie Johnson played a judge, and he was always finger wagging at you're a jibber jabber. Anyway, yeah. Normally that's what I would have thought.
So
but
the next
nope.
question we have, CJK says, is Travis still a full-time attorney?
Yes.
Okay. Can't get quicker than that answer. Lone Pony.
Wait, how do you define full-time? I'm kidding. I'm full-time one.
Well, that would depend if you're a defense attorney or a prosecutor. Lone Pony wants to know, where did you go to law school?
Went to Pepperdine for my normal law degree, and then I did a postgraduate degree at Yale. We call that a LLM, or there's a few different designations for it, but Pepperdine and Yale.
So Yale, that's an online school, right?
Yeah.
Well, Travis has a legit education.
Total mail order lawyer here.
You put your money down, and yeah, they let anybody in.
Is that accredited?
I don't know. They may have decertified them, for all I know.
Yale,
I think there's 3 justices on the Supreme Court that went to my school.
is Travis a member of Skull and Bones? And does that mean he's a Mason and involved in the case, and that's why
Probably
his opinions are the way they are? I got lost in the back half of that question.
I did. The ice was rattling. Can you say it one more time, please?
I said, are you a member of Skull and Bones and are a Mason, and that's why you got into this case?
I can't say. And so someone does need to give, and this thing's complex about the Odin, Nordic,
Pagan
pagan heathenism, and why it's super complex in the U.S. is a number of reasons, because every kid in Norway, Sweden, Iceland, they all learn about Odin, and that, Norse mythology is in a lot of things. It's in Dungeons and Dragons. It's in, and so they learn about Odin and Loki and all the other stuff. Just like in the U.S., we learn about Greek and Roman gods and Jupiter and Zeus. And
Do we?
yeah, we were supposed to. I did. Anyway, but I learned civics too. They eliminated that, and they eliminated cursive writing. But in any event, so there is an aspect to it. And then I don't know how much Nordic pagan heathenism is, actually an organized religion there. I don't, in those countries that, historically where the Nordic Vikings were, I don't know. But then I do know it came over here and then was used as a way to get prisoners additional rights in prison based on religion. So I want to grow a beard. No, well,
And drink mead.
we're making an exception for Muslims. My religion, you need to have a beard longer than a fist. What's your religion? And so it's in Title VII cases, which is in employment law. You can't discriminate based on religion if there's a reasonable accommodation that can be made. So those cases are like, I don't want to get vaccinated. It's, against my religion. What's your religion? Well, you don't have to prove that you go to that church every week. It's just you have a sincere belief is all you got to show. But
Right.
then there's a component. There's a component of white supremacy in gangs in prisons that call themselves something. There is another thing called Christian nationalism, which, to some, they've written about that they dress this Christian nationalism, that's code for white supremacist organizations. And then, who tracks all of this stuff and is usually pretty credible is the SPLC, Southern Poverty Law Center. And they track hate groups. The Supreme Court cites to them routinely, the Department of Justice. They successfully were able to sue the KKK and get a huge judgment against them. First time ever happened. And but anyway, they track all of this stuff, track online, discussions, and they've identified, I'm not even going to say it because I'm going to get the words right, and I don't want to get it confused with Nordic pagan heathenism or anything else that is somebody's sincere religious belief. But, there's a lot of confusion as to what's what. And what I initially read up on is the Southern Poverty Law Center and Nordic Odinism. And so you have to be really careful how it's designated. But, more importantly for this case, regardless of whatever. So there's two things I've observed and said many, many times, either in chat or as a panel member. I've never seen anywhere on a uniform, whether it's a police officer, sheriff's deputy, corrections officer, in a jail, in a prison, never seen a patch that identifies you with any religion, whether it's Christian, Jewish, Muslim, it's not allowed whatsoever, except a chaplain who's usually like a reserve officer and volunteers to do it. Chaplains
Right.
of crosses or Star of Davids, but outside of that, there's no patches like that whatsoever. And I just thought that was really odd that, and I never understood how the court came up with the conclusion, or the, DA was arguing to the court and bought it, that they were being dishonest about what was happening. I know the thing about the photo, but they're like, look, we know we deposed these investigators who are now retired, and they testified they saw signs that they had conflicts with another group of investigators, that outside agencies agreed with these things, and there were apparent signs of odinism at the crime scene, and and then that became a basis for transferring him. There are odinous guards watching him, and the best they could do, and this is when I was first coming into the case, and this blew me away. I don't know anywhere else where this would happen. And the warden does an affidavit. He doesn't even have to come in and testify. No, there's no odinism going on. I have two guards who wear patches associated with Nordic pagan heathenism, and they were talked to, and they've agreed to not wear their patches anymore. And I'm thinking, what the fuck? I mean, you don't know that people are wearing religious patches in your prison? I mean, and that you didn't haul them in immediately and say, it's a violation of policy, or you don't have policies that what if one of them had a KKK patch on? What if one of them had a Jewish patch on, and they're in the Muslims? It just was flabbergasting. And it's like, and my impression at the time, it may have been mistaken, is that, see, they're not being honest with you, Judge. There's no Odinist in prison watching him. They're Nordic pagan heathens.
I think the part where they're claiming that they're being dishonest is about him being treated poorly, which I still think is kind of bullshit myself. But I think that's the part that they're saying that they're dishonest about, because that's the part that the warden testified about. I want to say he did testify in person.
Well, and we can go on and on about the whole Odinism thing and the prison guards. I mean, the bottom line is the prison guards were wrong to have done what they did. It clearly should. I think that no one had a full understanding of what Odinism was to begin with when this started. I don't think Rosie or Baldwin knew what Odinism fully was before. I don't think McClellan probably knew what it was. Librato and Scrimmon said they didn't know what it was. So I mean, we could do a whole episode on that, and we've been on for 3 hours and 40 minutes. So unless
let me just finish the second part.
Absolutely.
So the second part is, when I was involved peripherally on the outsides of West Memphis 3, one of the experts that they had brought in, that Dennis Reardon's the best post-conviction lawyer in the country then and now, and his partner Mike Horgan, they had gotten, and you all know this guy from the FBI and their profile unit, and he came in and did a profile about the West Memphis 3 thing and what he saw. But as you all know, that was supposedly done by a satanic group to these 3 boys. And the FBI at that point, late 90s into the 2000s, they had no confirmed case of a ritualistic murder in the U.S. Of all of them, no murder done in the name of what have you. And I don't know that that's changed. And so even if this had Odinist markings or telltale signs, what I've been trying to research and what someone needs to research, it doesn't appear to me that ritualistic killing or murder is part of what Odinists believe or do. And
It's not really a thing that any religious group does in the U.S.
Well, so does anyone know where the last ritualistic religious sacrifice occurred in the United States?
If it's Indiana, I'm going to close this down right now.
It would depend on the definition, but I don't really want to parse through that.
I don't know if there's ever actually been one.
The last one was in Hawaii in the early 1900s, before it was even a state. And the countries that have or had ritualistic human sacrifice, Asia, but all countries, Europe, Northern Europe, they all had them, but they ended them like in the UK 12 centuries ago. And so it's, the Aztecs, whatever, 4 centuries ago. There have been cases where they purposely do things to throw investigators off track, including Catholicism, Christianity, bunch of things. They'll scrawl a pentagram at the crime scene to throw people off. They'll write stuff in blood like the Manson family did to throw people off. But, I'm just interested, so some of the questions we had earlier, it's how much are they going to have to show? And, I don't know how much, is they're going to be able to show on it. I think most of what they're going to have on that subject is that the investigators didn't pursue enough the information they had. And then somebody asked last about tool marks. I've had cases involving tool marks. It's sketchy, but it's not junk science. It's still accepted testimony in many jurisdictions, and apparently in Indiana it is. And that's a real key fight. What experts, it's a key part of the case. What experts does the defense have to counteract tool mark evidence? Some jurisdictions, tool mark stuff's out, showing where it once was allowed, it's now excluded. But, that's a whole another show, but I did want to answer that.
Thank you. CJK, it was a very important question. Does Travis have a beach house?
Yes.
Oh, well, there you go. It pays to be a defense attorney. Carol says, Travis, have any of your clients ever been given the death penalty?
No, I'm not death penalty qualified. I've volunteered on some death penalty cases to help out on certain aspects because of particular knowledge I have regarding investigations and different things, but very, very minor role. And then on post-conviction, I help on a couple of small pieces asked to help on, because in Texas, we have the death penalty big time. And I worked on a couple that ended up being an exoneration, and again, small pieces compared to what other attorneys did. And one was a commutation to life. But no, that's a whole nother level of practice, and people that are truly qualified to handle a death penalty case are few and far between. We've gotten better in Texas on what the minimum qualifications are. They're much more stringent than what they are in Indiana, but we have a terrible track record of until the last 10 years what qualifies as a death penalty attorney.
That surprises me, because I mean, I don't know what the reality is, but on my side of the border, we always think and hear of Texas as being one of the tougher states with the death penalty. Like, don't commit your felonies, your capital
I
crimes.
think that's still true.
Oh, no, it is. No, we give the death penalty out. We convict more people and sentence them to death, and we execute more than any other state. And it's still that way. What maybe I misspoke. What I was saying is they have upped the standards for what is required to defend somebody that's facing the death penalty. And it wasn't because Texas all of a sudden woke up and said, "Oh, we want better quality of counsel for death penalty cases." The legislature got tired of the U.S. Supreme Court reversing for new trial over and over and over again cases for ineffective assistance of counsel. For example, we had one case down in Houston. The attorney, everybody agreed, was asleep for periods of 10 to 20 minutes every afternoon during the trial. And the Texas Court of Criminal Appeals, that's our highest appellate court, said, "Oh, well, he wasn't asleep. Yet they didn't show he was asleep in really important stuff." And the U.S. Supreme Court just laughed at that. You got to be kidding. What's it going to take for you clowns to understand what effective counsel is? You got to start with he's asleep, not asleep during the evidence. So it wasn't because the Court of Criminal Appeals is trying to help out criminal defendant. Legislature tired of paying for retrial after retrial after retrial because of incompetent attorneys, and the Court of Criminal Appeals just rubber stamping this stuff and absolving all of this responsibility for having competent counsel. But no, it's we still are the leader in dishing out the death penalty sentence and then carrying out that sentence. There's no question.
Hello?
I'm not. I mean, I don't want to get into it, but we're just kind of talking a little bit in chat about maybe scheduling you for a future day to talk about non-Delphi stuff, some other cases I know that you had mentioned to me a while ago. I want to say even a couple of months ago, that you might have been indirectly involved with West Memphis 3, and get your opinions on some of the other high-profile cases. But I don't know where. Adam.
Yeah.
I'm right here.
Whenever we can do that, I really want to talk about that. You know, why is, there's no crime in Canada. There's no kidnappings. There's no mistreatment of children in Canada. And, why is that?
Actually, Travis, Charmaine and Sunny do an entire series called Canadian True Crime on,
Really?
on
But the
Saturday.
numbers are lower.
Where can I
Our
find
numbers
that?
are a lot lower, but what you have to understand is our population is also a lot lower, and our gun control is a lot stricter.
And
I'm
it's too
not
cold to
saying
go outside a lot of the year.
a lot of the year, and a lot of a lot of our population is I can't even say a lot, but we've got
Drunk.
a very large Indigenous and we do have a lot of crime, and a lot of it is really tragic, but none of it is considered high profile. You've got Bruce MacArthur, you've got the Ken and Barbie killers, you've got guys like that, but it has to reach that level to get international attention here.
The Shermans.
Yeah.
I would love to.
We're still not doing that case. I'm sorry, Aspen.
I'd love for you guys to do a show one day, and it may be a controversial one, but talk about why we do seem to have so much crime
In Canada.
No.
Like I mean, I'm in a small town. I'm in a town that's about the size of Delphi, and I don't lock my doors. I don't, it's bad. I know it can happen anywhere, but it's a different way of living here.
Right.
We don't have the same day-to-day concerns that everybody.
And a lot of Americans don't realize it.
No, I do want to say, Miranda, I agree with your comment 100%. Crimes against Indigenous women get overlooked, both in the United States and in Canada.
Yes, and I've been struggling to
men.
write the Highway of Tears episode. I've got a big one, but it's not just an episode, right? It's going to have to be a series to give it the attention that it deserves. It's just so deep.
Yeah,
and every single case that we cover, it seems that the RCMP just doesn't take these disappearances seriously until they're forced to.
I agree.
It's the same in Australia, and I've heard Charmaine talk about. So I think in Canada, don't they even have Apology Day for the treatment of
Reconciliation Day, the Day
children.
of Reconciliation.
What is it?
The Day of Reconciliation. It's September 30th, I believe, every year, and that's that came about because of residential schools. Basically, it became very public knowledge that the government and the Catholic Church were. I mean, they committed atrocities against an entire people, and for whatever reason, it wasn't widely known or talked about until relatively recently when they started finding these mass graves. So as part of a apology from the Canadian government to the Indigenous community, they came up with the Day of Reconciliation, which is, I mean, it's a lot of people don't even understand what it means.
Right.
Why it's there. All they know is they have another holiday every year. So,
right. So, yeah, Miranda, that was a great observation, and it happens in Australia too, everywhere. And then even here in the US, the disappearance of certain children get much more media attention, typically, blonde-haired, blue-eyed little girls. It explodes. But Sonny and you guys were covering, clearly a person of color, African American, that went missing, but these are philosophical and policy decisions that, it's not right that somebody who might be low income from a particular area goes missing, and it might get a brief spot in local news, but other children, spreads like
Right.
wildfire.
It happens. I think my algorithm is filled on social media with missing and endangered individuals, and it's insane the amount of them that pop up every day. Whereas there's typically only one or two that are happening nationally, attention-wise. But there's no shortage of missing children.
Yeah, I'd be happy to do a show on West Memphis 3, but I'd be even more happy to do a show about, what the data from the Center for Missing and Exploited Children, which was, an act of Congress, created money for, a governmental agency to pool resources from all over, because pictures on milk cartons, that's from my era. That's how, that way before the internet, and there were plenty of missing, unfound children that there was a different face on milk cartons every month. And every brand of milk had it, but, they developed that center, how many children go missing every year in the U.S. and what's the breakdown by gender, age, and nationality or color?
460,000
Wow.
go missing every year.
Every year. That's by the FBI.
I don't know if it's the same stat. Sometimes that's skewed because
Well,
let's say a
most of them-
teenager runs away and goes missing. If they come back home, then they run away again. That's another missing person to the
Yeah,
stat.
of course, absolutely, yeah. I'm just
But it's
giving you
still
a
a
broad
shit ton.
number.
It's
Still
probably Sunny. She keeps running, over to Seattle to party, and then
It's
they
exactly
keep
what's
bringing her back. And that's probably half of it right there, 450. So let's say they do it 4 times. They run away from home 4 times. And so it's only 100,000 individual people go missing. How many deaths?
Right. Well, according to the Child Crime Prevention and Safety Center, 840,000 kids go missing every year, and it's every 40 seconds.
Yeah, I saw something like that too. Like, it's just insanity. In Canada, I think we're at like around 20,000 a year.
I pulled up some stats from CDC yesterday.
And again, 90% of those are all found safely. It's, so of course.
Well, the ones I pulled up were deaths of children, and for children 17 and under, homicide is the number 1 cause of death.
Yeah.
And then
it might be for women still too, right?
Pardon?
Is it for is it for women, or is there a natural one? I think homicide is still like number 2 or 3 for women.
Not sure, but it was for children. I just looked up that, and then by, and that's one of the things that's spiking. Violent crime overall, it's been trending down. Deaths of children during the pandemic by homicide spiked up, 20, 30% in 21, up 20,
Domestic
30.
violence in general.
Yeah.
So yeah, those are, things we get. And, I really like talking about stuff on this channel. One day maybe we'll talk about all of this infighting and finger pointing, not with this channel, but other channels, which is kind of bled over here. They're stalking Aspen. When really it was me. I created all of the, I have 42 different account names that I use on social media.
I can barely log into the one I have, let alone multiple. But
I
doubt we'll do an episode.
Nothing but time to go into different things and claim all of the knowledge and information I have about this case. And
Can I
may not talk to Nick, but I talked to Nick's Taylor.
Well, really quickly, Anthony France asked this question forever ago, and I feel bad because I haven't gotten to it yet. But this is the last question I have from the chat. Anthony France said, "Travis, do you think that they really want to go to trial? If that bullet matches his gun and or numbers from a box of bullets from his home, that's pretty damning evidence without his confessions even."
Anthony, it certainly could be very damning evidence, depending on, the nature of it and the characteristics of the tool marks. The expert I use, Lucian Haig's the son of Luke Haig. Luke Haig testified in the Armorer trial recently, but he's the president of that association, ballistics and tool marks, and that evidence has become weaker and weaker, even on fired ammunition, where more marks are left because more force happens. With mass-produced guns, the markings have become more and more uniform. So it's hard to say. Is it as strong as fingerprints? Not even close. And there's problems with fingerprints. Is it as good as DNA? Not even close. Is it better than hair comparison? Probably. Better than fiber comparison? Way better. But and they've changed the way that experts are supposed to testify on this stuff. And used to be, oh yeah, these are a match. Now, the different societies that govern these experts, now, the most that they're able to say, supposedly, is, I can't exclude this gun as the contributor, is the wrong word, is the contributor of the markings on the unfired cartridge. It's not as strong as ballistics evidence, which is the comparison of two lead projectiles that have been fired through a gun, which that in itself is subjective. And there were a lot of criticisms of that in the national report. That's another subject we should go through. The national report that came out in 2015 that questioned a lot of the forensics, especially bite marks. And
That would be interesting.
yeah, but I'd love to see someone do one on what are the differences on Odinism and whatnot. But do they really want to go to trial? They may not have a choice. And even putting whatever the confessions are in the phone call or whatever aside,
Right. Which they won't.
That's that in and of itself, there are top experts, qualified and legitimate experts in tool marks, including former tool marks people at the FBI lab that can poke a lot of holes in tool mark evidence, marks left after it's been cycled through a gun. But we'll need to see. And then, of course, you can never take this stuff in isolation. If the statements made in that telephone call or anywhere else and the recordings, they're going to have to be taken in conjunction. And but to your question, they may not have a choice.
Well, yeah, clearly.
They it's not up to the defense what offer they get.
Right.
And, I assume that death penalty is off the table. I don't even know if life without parole is if that's one of the options the judge has, if there's an aggravating factor found. I tried to ask those questions when Kara and
Well, and now we have the amended charges. So
what's that?
I said, well, and now they presumably will have the amended charges added. So the aggravating factors might not even matter, right?
Yeah. Well, so I said, is one of the reasons why they're amending to this other charge is to get the death penalty on the table or life without parole. And neither one, Kara, I was in chat, and I think both got asked that. Neither one had a really good, solid answer to that. They said, well, I don't think so. It wasn't real, but, I don't know. And that, no, it wasn't, no, the only way you can get life without parole is if you do this, but I can't figure it out. I can't figure out if there's a deadline to file a request for the death penalty, and I can't.
Yeah.
Because if there's no life without parole, which I think there is, if there's an aggravating factor, and kidnapping is an aggravating factor, then you can, if the jury finds that aggravating factor, then the judge can give life without parole. If not, if it doesn't qualify for life without parole, the max under Indiana law for murder is 60.
Okay.
And we saw with Garrett Kurtz, he said what he said in order to get 5 knocked off, 65 to 55. And I'm not sure what the parole eligibility is in Indiana. And then here in January of this year, he took another plea deal on the death of that man that initially was completely screwed up and determined to be accidental. And then they finally got that DA, a new DA got elected, and he picked it up and said, I'm going to get justice for this young man. And they got another plea out of him for 55, but concurrent. So, consecutive, meaning he's got to serve the 55 and get parole on that before he starts the 55. So it's 110 years for him. And the likelihood is he'll never get out of prison, which is probably a good thing, because he was escalating every week. As every week went by, he was escalating.
Yeah. And I think we can probably leave it at there tonight. We're at 4 hours and 12 minutes. Charmaine, is there anything else that you have to ask Travis?
No, not tonight. I just, I'm super thankful that he put up with us for so long.
I know. Thank you, Travis. Thank you so much. I can't imagine what this would be in billable hours.
That's a very good point.
Either way,
it'd be a beach house. Thanks for having me. I really enjoy being on these panels, and I really enjoy our group here. Clearly the smartest group in the YouTube domain. Hang out here. Y'all must have an entrance exam or something.
No, I think it's just a lot to do with the level of respect that everybody seems to have. Like, everybody's so kind and respectful, and they ask really great questions. I love it here.
I don't know how
it's kind of annoying, but
I don't know how Sunny can avoid it when she has such great people taking over her channel for her.
Ivy,
thank you so much for being here.
Yeah, Ivy, thank you for being here. Did you have anything else to say to Travis?
No, I'm sure I'll think of something later for next time. I really would love to be involved in a show about any of the topics that you were talking about earlier.
Mm-hmm.
Absolutely. You have an open invitation here. And I really appreciate Charmaine for setting this whole thing up tonight. I appreciate Ivy for being here, and I appreciate Travis for talking and giving us all of the insight that he has tonight. We picked your brain for 4.5 hours, basically, and you didn't miss a beat. So thank you so much.
Oh, you're welcome. I hope somebody got something from it.
I think we all did. Thank you.
Yeah, absolutely. Okay, well, if anyone doesn't have anything else to say, I think I will hit the outro. So, good night, everyone. Bye. Well, hey, Travis, thank you so much. I'm going to head off of here tonight. And Ivy, thank you so much as well.
I didn't know you were still here. Talk to you later.
Yeah, you're welcome. Thanks. We'll see you soon. Thanks for having me.